Good evening. I would like to call to order this special meeting of the San Francisco Ethics Commission, the continued hearing of the official misconduct proceedings relating to Sheriff Ross Mirkarimi. We'll start by taking the roll. Commissioner Studley.
Here.
Commissioner Liu.
Here.
Commissioner Hayon.
Here.
Commissioner Rennie.
Here.
Over the course of the last
I understand there's a couple of rooms. I want to say thank you to the other people in the other rooms. I cannot tell you on behalf of me and my family how grateful we are. Thank you very much.
During the course of the last month, there will definitely be an opportunity for public comment, and we welcome your views, but if the crowd could please allow us to conduct our business, we would appreciate it. Thank you. Over the course of the last month, the parties have submitted a number of briefs, and we want to, on behalf of the Commission, want to thank the parties for their diligent efforts in doing so and in complying with our deadlines. I think much of the information that was provided was quite helpful. There are a number of things we need to address tonight. So the procedure that I would propose, subject to the views of my fellow commissioners and the parties, is that I will introduce an issue that was previously briefed, invite comments from the commissioners, and if the commissioners have any questions for the parties or any party wishes to be heard on the matter after hearing the commission discussion, we will invite you to do so. Is that acceptable to the commission?
Yes. Yes, thank you.
Any objection from the parties on that? No. Okay. Because I think a lot flows from the Commission's decision on whether live testimony should be heard, I think we should start with that issue. We had asked for briefing the parties' views on whether the Commission should act just based on written declarations or should also consider live testimony under oath. My view after reading the papers and hearing the parties is that I do think some live testimony would be helpful for the Commission in making its evaluation and in reviewing the evidence. I welcome other views from my fellow commissioners on whether that should be the case. Commissioner Studley.
Can you describe how we would narrow the witnesses and the testimony to the issues that are appropriately before us?
In my view, I do think that some narrowing is going to be required. So my thought was to get into the discussion of specifically which witnesses we would see a little bit later after we discuss some of the other preliminary issues. But I certainly share your concern about the breadth of the witness lists. Commissioner
My
Hayon.
question is it all, do we have to decide that it's all live testimony or all declaration, or can we have a combination of the two?
I was envisioning a hybrid where some evidence could still come in through declaration, as we had previously discussed, but that for certain individuals, live testimony would likely be helpful to us.
And to piggyback on what Commissioner Studley just asked, I mean, there is a very long list of witnesses. Were we to ask all of those witnesses to participate in this hearing, and it seems to me that that wouldn't be necessary, that it would be great if we could narrow the list to really those that are truly relevant to the case at hand.
I concur with that.
I would agree with that, and also just narrow it to where we think that we have credibility determinations to make. I think that's the only area where we really need some limited live testimony. Thank you for reminding me to speak into the mic. I was commenting that I do agree that some live testimony would be necessary, but only limited to those areas where we would need to make a credibility determination, and certainly not the lengthy list that we've seen. I think we can narrow the issues.
Would any party like to be heard on this issue?
Yes, good afternoon or early evening. Shepard Kopp again on behalf of Sheriff Mirkarimi with my co-counsel David Wagner. In our view, the proposed witness list that's been given to you by the mayor is excessively lengthy. We believe that many of those witnesses are irrelevant to the determinations that you're going to need to make. And also, in our view, the only two witnesses that definitely should be testifying live are Mayor Lee and Sheriff Mirkarimi. We think all the other witnesses could be handled by declaration, subject to the other party insisting on the right of cross-examination, and if you decide that you need to hear that.
Mr. Kopp, I think that issue, like I said, the specific issue of who we hear from will be addressed later. So this really is limited to the question of should we have some live testimony? And it sounds like you're amenable to that, and I know the mayor wanted some live testimony as well, so I don't expect any dispute from the parties on this.
Yes.
So because there are so many decisions to be made tonight, I'm also proposing that we take one vote at the end addressing all of the issues, particularly when it sounds like there's unanimity on an issue. Is there any dissent to the view that we should entertain some live testimony at a hearing? Mm-hmm. Okay, then moving on to the next issue. The standard of proof to be used. The sheriff has proposed a preponderance of the, a beyond a reasonable doubt standard. The mayor has proposed a preponderance of the evidence standard. In light of the briefing and the relevant authorities, it appears to me that a preponderance of the evidence standard is most appropriate here. Beyond a reasonable doubt seems to be something that would apply in a criminal matter, and I personally do not see any legal basis for applying it here in our commission proceedings. Again, welcome the views of my fellow commissioners on this. Commissioner Rennie.
Well, the only question I have is on issues of fact, which may go to the question of whether or not the sheriff committed some criminal offense other than the one to which he pleaded guilty. I wonder if there might not be a requirement of some higher standard of proof that the mayor has got to establish that, in fact, those criminal offenses occurred. I agree that overall that certainly on the question of our recommendation and other decisions that may be made in the case, a preponderance of evidence seems the appropriate standard. But I'm just troubled by if, in fact, the mayor is relying on acts which he claims were criminal acts, then I question whether or not the mayor doesn't have to prove by some higher standard than merely a preponderance of evidence. I don't have a firm position on it, but it is a concern I have that there are some issues which clearly seem to be appropriately a preponderance of evidence, but if there is going to be a reliance on criminal conduct other than that to which the sheriff pleaded guilty, I have some reservations.
Commissioner Rennie, I share your concern, and the way I reconcile it is this. We are not tasked with finding whether or not Mr. Mirkarimi committed crimes to which he has not pled. We're tasked with making factual findings about whether certain actions were committed and whether those actions constitute official misconduct. So in my view, I agree with you that if we were trying to determine whether he committed crimes, that the reasonable doubt standard would apply. But at least to me, in light of our task, I find no legal basis to use a higher standard than preponderance. Any other views from the commissioners?
No, I'm in agreement. I think that we're not called upon to determine whether certain crimes were committed. We're called upon to determine the facts of what happened and then to determine whether it constitutes official misconduct. And I do think that in the civil proceeding, a preponderance of the evidence standard is most appropriate, especially given that that's the standard we normally use at the commission.
Commissioner Studley.
And I would just add that I agree with that. Since we are not making any findings with the consequences that would attend to a criminal finding, we're making recommendations to the supervisors. I think that's an appropriate standard. Moreover, we have the option, when we get to the point of developing our recommendations, of indicating if they meet an even higher standard or level of certainty, if we want to and we think that the facts warrant. So I think for all those reasons, this seems appropriate to me. But it's a fair question, but I think that our job is a little bit different.
Commissioner Rennie.
I agree with you when you say we are only fact finders, and if we weren't required to make a recommendation to the Board of Supervisors, I would be in complete agreement. But if our recommendation is going to be predicated on a finding that Sheriff committed some act of official misconduct beyond that to which he pleaded guilty, then is where I have my concerns. But I reserve that, I think, as we go along. I just raise it.
Would either party like to address this issue?
Yes, please.
Mr. Kopp.
As the commissioners have hopefully gleaned from the filings that we've submitted. Thank you.
There are some of us who are disabled with hearing loss.
No, I'm sorry. I could hear myself. That's why I thought I was transmitting. How's this? As the commissioners have probably gleaned from our filings, we see these removal proceedings as distinctly different from any other determination you might routinely make for some other non-elected public official. And since the only published appellate decision that we can find on a charter removal proceeding is the Mazzola case, and since in that case the supervisors at that time got it wrong and were reversed, we look to the state code, which has that higher burden of proof. And we think, particularly in front of a commission like ethics, the highest level of due process should be extended to an elected official. And that is why we believe that's the appropriate standard, because we certainly don't want to have a situation where a determination is made that the sheriff was not accorded that high level, and any determination you make or the Board of Supervisors makes down the road winds up getting reversed.
Thank you. Ms.
Good
Geiser.
evening, Commissioners. I just wanted to address Commissioner Rennie's concern and point out that the elements that we need to prove here under the charter, there are two prongs to the definition, and neither one of them is really the definition of a criminal offense. First of all, it can be wrongful behavior, that's willful, by a public officer in relation to the duties of his or her office. That does not state a crime. And it could be that a crime satisfies that definition, but we're not here in urging a finding of misconduct to prove any sort of criminal behavior. We know from Sheriff Mirkarimi's guilty plea that he did commit a crime, but that's the only way in which the commission of a crime and the plea and the sentence that flowed from it really play in. We do allege other things that perhaps are crimes, could be considered crimes, but those would be the subject of a separate proceeding by separate fact finders under a separate burden of proof, if indeed that were even an option, given the fact that many of the facts and circumstances were already adjudicated in criminal court and resolved by the guilty plea. So I just want to make clear that it may be that some of the other conduct could be considered criminal. As I understand it, that's not an uncommon situation before the commission. And nonetheless, you do not act as criminal fact finders. You act as an administrative tribunal, applying the preponderance of the evidence standard to the civil infraction that goes along with or accompanies the criminal offense.
Any questions from the commissioners of either party? Ms. Kaiser, would you like to address Mr. Kopp's points with respect to Missoula and the state code?
Absolutely. As we made clear in our briefing, it's our position that the charter controls this proceeding, not the Missoula case. And the Missoula case was not the decision was not rendered with the benefit of the current definition of official misconduct that's in the charter, nor did it say what the definition of official misconduct had to be in the charter. It's true that it referred to a definition from Black's Law Dictionary, which the city ended up adopting, the voters ended up adopting as part of the definition of official misconduct. But any gloss, limitation, other holding, other discussion in the context of that case actually has no application here. And the reason why is that in the Missoula case, what was at issue was not, as has been discussed here, the timing of the misconduct. What was at issue was the relationship between the alleged misconduct and the officer's position as an airport commissioner. And what happened in that case was Airport Commissioner Mazzola was also a union official and had been a union official when he was appointed. And at some point, his union, along with many other unions in the city, went out on strike. And he recommended the strike, but did nothing in his official capacity as airport commissioner. And the Missoula court ultimately held that there was no relationship between his actions as a union official and his actions as an airports commissioner that would be sufficient to merit his removal. So when it was emphasizing in office, it was emphasizing the relationship or the connection. And the mayor agrees there must be a relationship. But that case has absolutely nothing to do with the timing of the misconduct. Moving on to the second question, which is how does this relate to the government code and to the state removal proceedings? Actually, if you look at the government code, you will notice that there are two different procedures for removal. One of which is the procedure that the sheriff has been talking a lot about, and it's called removal other than by impeachment. And it does have a process for an indictment by a grand jury and a trial and all of that. The other set of provisions, however, is about impeachment. And those procedures are actually what this procedure much more closely resembles. The Assembly brings to the Senate a charge, an impeachment of an elected state official. The Senate holds a trial, and the Senate then votes by 2/3 of its members whether or not to remove the statewide elected official. That sounds like this procedure. It does not sound like this grand jury indictment, et cetera. And in any event, as I think is most important here, what really controls is not this law under the state code or that law under the state code or some other law of some other state altogether. What really controls is the charter in this case. And to the extent that there are holes in the charter that really can't be filled any other way, maybe there's a debate about what to import. But we didn't really find anything like that. We thought it was perfectly clear, given the charter language and the standard procedures of the commission and, you know, the way that these sorts of inquiries are routinely run, that it's not mysterious at all. And we don't need to go afield and borrow an entirely different set of principles and procedures.
Thank you, Ms. Cottage. You've answered my question. I don't know if others have questions. The next item that I would like us to consider and address is the type of evidence to be considered. The sheriff has suggested that we consider only admissible evidence. The mayor has proposed that we more or less follow the Administrative Procedure Act, which does allow some hearsay evidence to be considered. My view on this is that I am concerned with the use of excessive hearsay in a case like this. But that said, it's hard in a situation where you have adjudicators who are not a jury. I think the risk of some hearsay is not as high as it would be in the case of a jury. So I come out, my view is that I think we should allow some hearsay evidence. I don't think we should rely strictly on the rules of evidence, but I personally would caution the parties that we're not going to, I am, at least for one, would not be persuaded by if the only evidence on a matter was hearsay evidence. So, and I welcome the views of my fellow commissioners.
My question would be, is where do we draw the line? If we're going to have some hearsay evidence, are we going to decide on a case-by-case basis as it comes up?
Mike.
I mean,
Could you repeat the question?
I think, go ahead, Commissioner Han.
Sorry. My question is, where do we draw the line on hearsay evidence that is to be admitted? Will we decide on a case-by-case basis as it comes up?
Any other commissioners have views on that?
Well, having spent my life as a litigator and familiar with the hearsay rules, I think I find myself very close to the chairman's position that I would be reluctant to make any decision which relies primarily upon hearsay and would caution the parties that, at least from my point of view, I would try to exclude as much hearsay as possible, and realizing that it will have little or no influence on my decision. But I don't think you can probably do it any other way than on a case-by-case basis when they either offer it by affidavit or offer it by live testimony, and an objection is made by one side or the other, that we would rule on it at that point.
I agree with that.
I do too. I think that it does have to be taken on a case-by-case basis. We wouldn't otherwise be able to just rule in a vacuum or exclude all types of evidence in a vacuum. And I agree with my fellow commissioners that I'd give probably little weight to something that's presented only as hearsay evidence, but we can deal with that on a case-by-case basis as the evidence comes in or is offered.
Would either party be like to be heard on this matter? The next item I'd like to address is the issue of unanimity. We've reviewed the briefing by both parties. In my view, I just don't see the authority for requiring unanimity, particularly in light of the fact that the Charter specifically states what percentage of the Board of Supervisors is required to vote in favor of removal and is silent on what vote the commissioners need to take. I think our standard rules on commission action should apply here. So in my view, a majority vote would be sufficient to make a recommendation to the board. I welcome the views of my fellow commissioners.
I agree completely. I think we're unanimous.
Would either party like to be heard on this point? Yes, Mr. Kopp.
Yes, just to preserve our record, I know we've submitted our papers, but we do object to the commission making its recommendation on anything less than a unanimous vote. We disagree with the mayor's position that the commission is somehow in an inferior position to the Board of Supervisors. While it's true that the board will ultimately decide and must vote by a supermajority, we believe that they will probably take your recommendation and give it great weight. And so that's one of the reasons why, along with the burden of proof that we have proposed, we believe your vote should be unanimous on the recommendation.
Don't you think they'd give a greater weight if it's unanimous than they would to a majority vote?
Likely so.
Right.
Thank you, Mr. Kopp. Ms. Kaiser, we've gone your way. I'm not sure what there is to say.
I would just like to make the brief observation also for the record that you're sitting here as a quasi-judicial body, not as a jury, and a panel of multiple judges, even in a criminal matter, reaches its decision by a simple majority vote. There's nothing untoward or improper about that.
The next issue I would like to address is the specific witnesses that we would need to hear from. Now this, I expect some discussion and probably I expect this to be addressed by both parties. My initial reaction to seeing the mayor's list was that I thought there were far too many people on that list. Upon seeing the sheriff's response, I was mostly in agreement until I saw that the sheriff listed 17 witnesses himself. So, Mr. Kopp, earlier you said that you really only think there are 2 witnesses that need to testify. Are you saying that? So I shouldn't take the fact that you listed many of the same individuals as a indication that you don't object to those witnesses testifying. Do I have that correct?
Just so we're clear, we listed the witnesses out of an abundance of caution. We believe that many, if not most of the witnesses proposed by the mayor would only have a relevant evidence to offer, and we likely will not call most of the witnesses that we listed, and we certainly think that declarations would suffice for all but one of them. So that's where we stand.
To the extent that live testimony is required, well, I guess we've decided that. We have more or less decided that. Here are the people from the list that I think we definitely should hear from. The sheriff, Mayor Lee, Ms. Lopez, Ms. Madison, Ms. Haynes, Mr. Mertens, and Mr. Hennessy. I think the last few people are people who I could see potentially coming in by declaration if they must testify. Here's how I'd like to proceed with this. I welcome the views of my fellow commissioners on, first, whether there are folks I have mentioned who we think there's no need to hear testimony from. Secondly, if there are people that I omitted from the list from whom you would like to hear testimony from. And then I'd invite the parties to address the same points. And certainly when the parties address this, I would like to hear for any witness for whom you think we need testimony and who is not on the list that we ultimately discuss, I want to know what charge that testimony would relate to. So let me open it up to my fellow commissioners. Anybody on the list who you think it's either we don't need to hear testimony from, or at least it's a open question that we should reserve until later? Commissioner Rennie.
When you went through this list and said the witnesses who you thought we possibly should receive testimony from, were you referring to live testimony or testimony either by declaration, subject to cross-examination, or both?
It was a combined list. I think, in my view, I think the individuals who I would want to hear live would be the sheriff, the mayor, and Ms. Lopez, if she is available to testify. Others, I think, could come in by declaration. Now, if a declaration is submitted, I think we probably need to open up that witness to cross-examination by the other side. So it's not necessarily the case, in my mind at least, that a witness who submits a declaration would not appear. I think they likely would appear if there was any controversy as to their testimony.
And I wonder if I can ask a question of the city attorney and the sheriff's counsel, if they know the answer. When the charges were filed and there was a preliminary hearing, wasn't there live testimony and wasn't a transcript prepared of that testimony?
Commissioner Rennie, Peter Keith for the mayor. Are you referring to the criminal charges?
Yes.
I believe there was not a preliminary hearing on the criminal charges. There was a whole set of various proceedings in criminal court. I don't think they included a preliminary hearing. I may be incorrect on that point.
I may be able to shed some light on this. Because it was not a felony proceeding, there was no preliminary hearing where witnesses would have to show probable cause. My understanding is that there were some pretrial hearings, but I think that there was limited live testimony at those hearings.
Mr. Kopp is correct.
Do you know who did present live testimony at those hearings?
I know that Ms. Flores did, Ms. Christina Flores, one of our listed witnesses, and in that regard, we propose simply submitting the transcript of that testimony. I believe Ms. Lopez may have testified extremely briefly during those hearings on a narrow issue, but generally speaking, I don't think there was any testimony. Generally speaking, I don't think there was any testimony.
Is that not working?
Okay. Generally speaking, I don't think there was any testimony on the merits during these proceedings in the criminal action.
All right, thank you.
Other views of the commissioners on this issue? Perhaps we should invite the parties to address this. I welcome either side to come up first. Mr. Keith.
Thank you, Commissioner, or Chairman. I think from our standpoint, we don't want to have so many witnesses, and I think by stipulation we may be able to eliminate a few of them on background matters, and we've been working toward doing that. Our other proposal would be to essentially speed along the proceedings by proceeding by declaration. So rather than having a ruling from the commission that we simply don't want to hear from this witness, perhaps what we would like to see would be that witness simply testifying by declaration, and then there be an opportunity to cross-examine, but perhaps a time limit on cross-examination so that we could move things along and stay focused. There was one witness, I think, that we would want to add that probably would need to come for live testimony. That would be Ms. Williams. She was another one of the people who Ms. Lopez spoke with on the 4th and observed her demeanor on that date.
Let me just stop you right there, Mr. Keith. So are you saying that other than Ms. Williams, you agree that the only people who we need to hear from live are the sheriff, the mayor, and Ms. Lopez?
I think, if I recall, I think Mr. Mertens and Sheriff Hennessy was also on that list. From the mayor's standpoint, our interest is in getting this testimony before the commission, even if it's just by declaration. We would like to get that testimony before the commission. We don't want to lose the opportunity, for example, to get Chief Still's testimony, the chief of the Adult Probation Department, to talk about how a 3-year term of probation will affect the sheriff's ability to perform his duties and how it might create a conflict for him.
And Mr. Keith, I appreciate that your concern with respect to. I appreciate your concern with respect to witnesses appearing by declaration, and I think we should address that. But I want to focus on live witnesses right now. So you are saying that the people that you think we need to see live are Michael Hennessy, the mayor, Ms. Lopez, Mr. Mertens, and Ms. Williams. Do I have that correct?
Yes, with the exception that I'm not sure the commission does need to hear from Sheriff Hennessy.
I thought you just said we did. But
No. I was trying to fill out the list. If we were really trying to winnow it down and select those critical witnesses, he probably would not be on the list.
Okay.
And then, I mean, we do have our subject matter experts, but that's more of, again, the declaration issue.
This is just recipient witness testimony.
Yes.
Okay, so what is Ms. Williams going to offer to us that's relevant to any of the charges?
Well, we expect Ms. Madison's credibility to be attacked with regard to her recounting what Ileana Lopez told her. Ileana Lopez, in fact, told a consistent story to Ms. Williams that tends to corroborate the credibility of Ms. Madison. And I think the fact that Ms. Williams is telling both of these witnesses a similar story corroborates Ms. Madison's story. Moreover, Callie Williams is one of the witnesses who was part of the targeted dissuasion efforts, and so it's important that her testimony be heard on that matter.
Okay, let me start with the second basis. What is she going to say that's related to the dissuasion allegations?
She received either emails or text messages from Ms. Lopez around 7 o'clock on January 4th telling her, don't go to the police. What I told you earlier was confidential, which was very different from the conversation that she had with Ms. Lopez at 1 p.m.
And what is the connection between those statements and the allegations against Sheriff Mirkarimi?
That Sheriff Mirkarimi encouraged Ms. Lopez to dissuade Ms. Williams.
So, please, we really welcome the public here, and I know many of you waited a long time to get in, and you will have your opportunity to speak. But if you could please allow us to go through our proceedings, I truly would appreciate it. And you have a witness that's going to make that connection between suggesting that the sheriff encouraged Ms. Lopez to dissuade other witnesses?
It would be the inference that would be drawn from the fact that Ms. Lopez so dramatically changed her position between speaking with Ms. Williams at 1 o'clock on January 4th and then 7 o'clock that night. When she spoke with Ms. Williams at 1 o'clock, she was expressing a fear for her safety. She told Ms. Williams that she was glad that Ms. Williams would be able to hear her if she screamed. And then and then when the evening rolled around, her views Ms. Lopez's expressions toward Ms. Williams had changed completely. During the intervening time, there were numerous communications between the sheriff and Ms. Lopez. We expect to hear Mr. Mertens testify to getting a call from Ms. Lopez to try to dissuade him from cooperating with the police, and he heard Sheriff Mirkarimi in the background. We would say that the commission should infer from that Sheriff Mirkarimi was aware of these dissuasion efforts and participated in them.
Any other questions for Mr. Keith with respect to Ms. Williams' testimony? Okay. Thank you, Mr. Keith. And what I'm going to do is invite Mr. Kopp or Mr. Wagner to come up to address the live witness issue, and then we'll deal with the declaration issue.
Well, I think that we would concur with what Chairperson Herr has just stated about the universe of witnesses that might possibly be needed live. That is the Sheriff, Mayor Lee, Ms. Lopez, Ms. Madison, Ms. Haynes, Mr. Mertens, and possibly Sheriff Hennessy. I don't think that live testimony by other witnesses would serve any purpose. But I would like to respond to something that Mr. Keith just said, if I may. This red herring of witness dissuasion has consumed an incredible amount of time and effort and energy, and it shouldn't have no place here, because what Mr. Keith just told you isn't true. Mr. Mertens was interviewed by the police, and when asked, did it sound like the sheriff was feeding his wife lines to tell you, to try to dissuade you? The response was no. It sounded like he was on another phone call altogether. So this has been a complete waste of time and an effort to publicly tar the sheriff with something that is not just unprovable, but false.
Mr. Kopp, can I invite you back up? Now, the list that you provided of witnesses who we think we need live testimony from was longer than the list that I provided, and I apologize if I was unclear. I think who we need live are, I put together a list of 3 witnesses who we would need live: the mayor, the sheriff, and Ms. Lopez. Counsel for the mayor has added Mr. Mertens as someone he'd like to have testify live, and Ms. Williams. So who I want to address, Lynette Haynes, who was on your list, and Ivory Madison, who is also on your list. Do you think that we need to hear from Ms. Haynes live?
I'm not sure that I can answer that question right here. It depends. We are hopeful that Ms. Haynes will at least provide a declaration. We know that she has been concerned about some of the efforts that the mayor has gone to try to interview her, subpoena her records, etc. I am hopeful that we'll be able to obtain a declaration to provide you. I think that depending on what the commission thinks of such a declaration, you probably will be in the best position to evaluate whether or not you need to hear from her live.
Okay. And Ms. Madison?
We're not going to offer testimony by Ms. Madison. If the mayor submits a declaration from Ms. Madison, we'll make the decision after we see the declaration as to whether we want to request that she appear for cross-examination. I'm not going to tell you right now that we think she is a necessary live witness.
Okay. So anybody who is on your witness list, you actually don't intend to call, except for the sheriff? Is that?
We believe that the essential live witnesses are the sheriff and the mayor. Everybody else is subject to whatever information is provided in their declaration. As far as the mayor's witnesses go, we may receive declarations and agree that we don't need to cross-examine, and we can argue our case based on what's in the declaration. So that's why I'm not trying to evade your question. I'm just telling you I can't necessarily answer it before I see the contents of their proposed testimony.
I understand. It was somewhat confusing, and I understand you've clarified, but when you list that many people on your list as affirmative witnesses, it does create some confusion here. But I think I get it now.
I apologize.
Is Ms. Lopez going to testify?
Well, we hope to have her testify. As some of you may be aware, she is in her native country. Her father has cancer, and that's an open-ended question. Even if she remains there, we are hopeful if we could make arrangements for her to testify remotely via Skype or FaceTime or some other form of communication. We would like to have her testimony, whether it's live or by video. But there are family considerations that are going to come first.
Okay. Any other questions for Mr. Kopp? Mr. Cobb, and one other question for you. What is your position on the relevance of Callie Williams?
Probably no relevance.
How is she different from Ms. Madison, if at all?
You know, I'm not even sure that Ms. Madison has necessarily relevant testimony. The sheriff has already stated publicly, and he'll say under oath, that he grabbed his wife's arm in a domestic argument. And that's, I think, the substance of what Ms. Madison and Ms. Williams would tell you, that Ms. Lopez told them about this argument where he grabbed her arm. So I'm not convinced that they have anything that you would need to hear.
Thank you.
Mr. Kopp, before you leave,
Maybe you should stay there for a while.
in view of what you just said, have you asked the city attorney that if we stipulate to those facts that you just said, will the city attorney agree that there's no need to put on witnesses who presumably are primarily going to testify to what Ms. Lopez told them happened?
Not in so many words, but just to give you a sense of what's happened, I believe it was last Monday or Tuesday, Mr. Keith and Ms. Kaiser sent us a fairly lengthy proposed stipulation, and we looked that over and gave them our response end of last week, and that fact was included. I didn't say, now that we agree to stipulate to this, will you agree that we don't, or the commission doesn't need to hear from Ms. Madison or Ms. Williams. So we haven't fleshed it out to that extent yet. I'm not going to leave.
I'm sure you'll be back up here again. Mr. Keith, if you could, I think we should take up the issue of witnesses by declaration. I appreciate that declarations are less burdensome for the fact finders than live testimony. That said, I'm still concerned that I don't want a situation where, because it's just declaration, the parties can submit whatever they want regardless of whether it's relevant. So I would like, even if you intend to, even if your view is that some of these people should come in by declaration, I'd like to know who on the list you would like to come in by declaration and why they're relevant to our proceedings.
Well, actually, Commissioner Herr, one of the benefits of this process of the back and forth with regarding witness lists and the briefing is that we came to the realization that with a volunteer commission, we can't have a 3-week, 8-hour-a-day hearing. It's impossible. So from our standpoint, what we're proposing is essentially to do everybody by declaration, even those witnesses who we put in should be live because we expected there to be cross-examination. I mean, if they don't want to cross-examine Ivory Madison, then that's fine. We're happy to just put in her declaration. We'll put in declarations for everyone, and it's subject to a right of cross-examination.
Mr. Kopp, can you come? Mr. Keith, maybe you can just stay. Okay. Do you object to that? Setting aside whether or not the commission will allow the parties to submit declarations from whoever they want. Are you comfortable with the procedure of direct examination going in by declaration and cross-examination live?
I'm comfortable with the procedure, yes. I'm not comfortable with the idea that they're going to give us 25 declarations and we're probably going to have relevance objection to 22 of those. I think that's unfair, not just to the commission, but to us. I think that all the subject matter well, I'll stick to the fact witnesses if you'd like me to, but there are many of these witnesses that we just don't think are going to offer information that's relevant. And then I'm not sure how the procedure would work. We'd have to submit something in writing explaining why we don't think that their testimony is relevant.
Okay, I think we're getting a little bit ahead of ourselves. I mean, I understand your concern, but and I'll give you a chance to address that. Is there any objection from the commissioners to have a procedure whereby direct examination comes in by declaration and cross-examination is done live? I think that's something that we had initially talked about last time.
I have no objection to that. I think it would streamline the proceedings given our limited capacity as a volunteer commission, and I know that everybody wants this to move along, and we certainly don't want this to drag out. But I do have the same concern about narrowing the witnesses so that it's not everybody under the sun, so that we're not pouring through 50 declarations trying to figure out the relevance.
Okay, I'm Commissioner Studley.
And I don't know if this will arise, but I'm wondering if there might be circumstances in which we might have questions about the declaration, but the sheriff does not have cross-examination from their perspective. And I wonder what we would do under those circumstances, how we would, since we have the ability to ask questions as well, when there's live testimony, whether we could get clarification on a declaration if the sheriff's counsel did not seek to weigh in. And maybe that's unnecessarily, did not seek to weigh in.
I think that's a good point, and I think that could be addressed. I mean, we could subpoena the witness if we independently thought that we needed to examine them and the parties had not indicated that they would appear live.
As I say, I have no idea if that will happen, but I don't want us to be left without the ability to clarify simply because the sheriff did not want to pursue that particular offer of proof. Thanks.
And are the parties in agreement that anybody who appears by declaration but does not appear for cross-examination, that their testimony would be disregarded?
Yes.
No, we are not. If the commission is going to take hearsay outside of the parameters of the California Evidence Code, I think the wiser course is to accept declarations and give them whatever weight you think they're worth. Because I can also envision a scenario, and not to get too lawyerly here, where they're going to try to bring in some evidence subject to an exception to the hearsay rule. And under the evidence code, we could then bring in hearsay evidence to undermine that evidence. So I think the better course is if there's a witness who submits a declaration and does not appear for cross for whatever reason, you accept it and you give it what weight you think it deserves.
Which is probably not going to be very much.
Well, it may not, but as I mentioned, we don't know what's going to happen with Ms. Lopez. If she is if we can't work out something where she can at least testify remotely, we may want to have a declaration.
Thank you. Any further comments from the commissioners about the procedure whereby we would examine or have live witness testimony?
Keith, did I understand you to say that it's your intention to submit a declaration on behalf of putting aside those who might come live, but that everybody else on your list you intend to submit declarations?
We would submit a declaration for the mayor, for every current city employee, and every independent witness that is not a witness who's not affiliated with the city who will agree to do it. And I will do our best and work with them as best we can to accomplish that. There is one witness, well, at least one witness who's hostile to us, Ms. Haynes. I don't expect that we'd be able to get a declaration from her. We would want to probably subpoena her for live testimony.
Okay, so let's go through your witness list then, because I want to hear why we need to hear it all from some of these people. So why do we need, what is Inspector Becker's testimony going to be, and to what charge in your charging document is it related to?
Well, both Inspector Becker and Daniele were the domestic violence unit investigators on the case, so they serve the function of collecting evidence. They would testify. They did personally observe Eliana Lopez. They testify as to her demeanor when they observed her. They observed Ms. Madison. They interviewed her. They interviewed Mr. Mertens.
But if we're going to hear from these people, why do we need to hear from the? If we're going to hear from Ms. Madison, Ms. Lopez, Mr. Mertens, why do we need to hear the same testimony from Inspectors Becker and Danielle?
Oh, we would attempt to limit their testimony to those things, such as simply their observations of the demeanor of Ms. Lopez, and just a summary of what they did in the course of the investigation.
And how is that going to? How is Ms. Lopez's demeanor going to help us decide whether or not official misconduct has occurred?
Because it pertains to the witness dissuasion count. It also pertains to what happened between her and the sheriff. The sheriff has maintained that there was a single grabbing of her arm in order to protect his son from his wife. And we disagree. We don't think that the facts match that. The facts were different, as Ms. Lopez told Ms. Madison and Ms. Williams. It was a much more serious conflict between her and the sheriff. And so every piece of evidence that we can get that bears on Ms. Lopez's demeanor and her mental state and the credibility of her statements at different times is relevant to the determination about what happened between the sheriff and Ms. Lopez.
Why, in what event would we need both Mr. Becker and Inspector Danielle?
We may not. We may be able to go with just one of them.
Okay, well, if you had to choose one of them, who would it be?
Yeah, without looking at great detail into the cron, I can't say, but we can go with one of them. We can select the one that has the most information about the conduct of the investigation and the observations of Ms. Lopez and others.
So you're in agreement that at least one of these witnesses should be removed from the list?
Could be, yes.
This may be time-consuming, but I think it's important for the commission to reach resolution on this. So for each witness, I'm going to solicit views of the commissioners and also Mr. Kopp's views so that we can sort of deal with them one at a time. Are there views from the commissioners on Inspectors Becker and Danielle?
I shared your observations and wondered why we need either of them. I'm not necessarily convinced with what I've heard, but it's up to the city.
Commissioner Rennie, you're not convinced that we need
either of the two inspectors.
Other comments from the commissioners on these inspectors? Mr. Kopp, would you like to address?
Well, I think you're going to probably get tired of hearing me say that witness is irrelevant. Those two witnesses are certainly going to be irrelevant.
Commissioner Hand.
I have a question that goes back to what you were discussing earlier about both sides agreeing to stipulate to the events that occurred. And if that happens, then do we really need either of these two inspectors? If everyone stipulates or agrees to the events that occurred, do we really need to hear from the inspectors? Doesn't that eliminate a whole series of witnesses that we would have to either get their declarations or listen to them live?
I think that if we did agree, that would, but I think that the parties do disagree about what happened.
Okay, so we're not going to come to an agreement where you both stipulate to the events that occurred.
We might be able to.
It sounded as if that was a possibility.
I think that we could come to an agreement that maybe facts A, B, and C occurred, but beyond that, we would disagree.
I don't see how these two inspectors are relevant. I mean, I would need to hear more as to how Ms. Lopez's demeanor would be probative of whether or not there was dissuasion by the sheriff.
I mean, one of the other things that the inspectors observed was Ms. Madison taking calls contemporaneously from Ms. Lopez and overhearing that conversation. So hearing the conversation where Ms. Lopez was actively trying to dissuade Ms. Madison from cooperating with the police, and hearing Ms. Madison's account of that call contemporaneously to it happening, which again tends to show that dissuasion is occurring.
But Ms. Madison would testify as to that,
Exactly.
right?
She would, but again, we expect her credibility to be attacked, and so this would corroborate her credibility as well.
I see.
And in addition, the observation of the call coming in from Ms. Haynes, as the inspectors were coming to the house, Ms. Madison was getting off the phone, having just spoken with Ms. Haynes, who was trying to dissuade her from cooperating. So that's an observation that they made that tends to support the credibility of Madison's testimony.
Commissioner Hand, was there something you wanted to say?
I'm fine.
Commissioner Studley?
I actually thought it was a reasonable balance to have one of these officers provide a declaration. I think the fact that we have this many questions means that there may be something, and I'd rather have it than argue afterward that we didn't have before us what we ought to, or have better testimony available by declaration than what we find we are able to get and find ourselves later backtracking. I apologize. I thought I was, and I think all of us are hearing the feedback as though we are. I apologize for that. My comment was, we're also trying to speak to the person to whom we're responding. I'll repeat what I said. I think that the earlier suggestion that you made that the city select one of the two officers and that we get the declaration from one officer, given the number of questions that we have about it and the issues that might possibly arise, seemed like a reasonable balance to me. I certainly think it's a fair question that we may not need it, but, and there are plenty of other witnesses that I think by stipulation we will not need, but this one might be helpful. And again, we can give it whatever weight we feel it deserves once we see it.
I agree with Commissioner Studley. I was kind of thinking that, and these are inspectors who apparently have experience with many cases of domestic violence.
Will you please speak up? Not just one person. We can't hear you back here.
Well, maybe
Mr. Chair, I wonder if it's possible to turn up the sound.
But
it's as loud as it can be? Yeah. What I just asked was whether it was possible to turn up the volume, and the staff is seeing whether they have any controls that would allow us to do that.
We will do our best, but please, try not to, let's try not to have interruptions and allow this process to play out as efficiently as we can. Commissioner Hand, please.
Well, basically, I'm in agreement with Commissioner Studley. I think it would be probably worthwhile to have one of these inspectors speak to their experience.
Any objection to that? Okay, so Mr. Keith, you're gonna be able to remove one of either Inspector Becker or Inspector Danielle.
I'll pick one.
Jan Dempsey.
She's testifying as only background matters. I expect that these are facts that we appear to be on track to stipulating to. Even if we couldn't reach a stipulation, her declaration would be very short.
But what would it be relevant to?
It would be relevant to the sheriff performing official duties of office in the interim between the election and being sworn into office on January 8th.
Mr. Cobb, I mean, do we have to have a discussion about this, or is there? Can you stipulate to that?
I think that we already offered to stipulate to pretty much every fact that this person would testify to. We might dispute the characterization of them as official duties of the sheriff, but I think we can probably work out the language.
Okay.
Well, isn't the sheriff the best person to testify to what he did during that time period? Why do we need somebody to come in here?
Yes, and he will.
From our standpoint, we have to date, we've had no ability to get the sheriff to testify about facts related to the case. We have to get the witnesses who we can get regarding.
Please, we are trying very hard to hold an orderly proceeding here, and I appreciate that there are vehement views of many people in the public, and again, I encourage you to share those views during public comment, but please, this is not the time. Thank you. Mr. Keith.
So because we don't have access to the sheriff, we have access to the witnesses, to the other individuals who are at the meetings. We have access to the other individuals who are at the meetings, so we would propose to use them. We don't know what the sheriff's testimony on this point will be.
Okay, well, I think we expect you guys to reach a stipulation on Jan Dempsey. We don't expect to see a declaration from the undersheriff. The undersheriff, retired undersheriff Jan Dempsey. Christina Flores.
This was the prior victim of domestic violence from Sheriff Mirkarimi. Her testimony.
I apologize, Mr. Keith, but please proceed.
That's okay. I'm used to it. The testimony that she gave she gave sworn testimony in the criminal action and was subject to cross-examination in the criminal action. We would simply attach the transcripts of that. It's well established under the evidence code that the testimony of prior intimate partners of persons accused of domestic violence is relevant to determining whether domestic violence occurred and also to establishing the kinds of power relationships that occur in domestic violence relationships that would lead to things like witnesses recanting their stories. And so her testimony is relevant for that reason. We don't think she needs to be called live because she's already been through direct and cross-examination.
Mr. Kopp?
Sure. This witness personifies the mayor's attempt to turn this into a circus. Prior testimony under Evidence Code Section 1109 is relevant only where the incident is in dispute, and it is not. I'll repeat. Sheriff Mirkarimi said he grabbed his wife's arm during an argument, and he will repeat that statement under oath to you all. So Ms. Flores would have nothing to add here other than create a bigger spectacle out of this thing than it already is. That's number one. Number two, this witness was not fully cross-examined during the criminal trial, and as a matter of fact, if you somehow decided that you wanted to hear from her, then we're going to need her live because there's plenty more questions that she'll be asked that she was not asked previously. I don't think that needs to happen. I don't think we need a mini trial that is sound and fury and doesn't signify anything, and I think that should be the last that we hear of Ms. Flores.
Views of the commissioners? Commissioner Rennie?
Well, I find myself, I guess, in a view that at this point I'm not prepared to say that that testimony would be admissible. But I can only make that decision, I guess, when and if he introduces the transcript. But it seems to me it should be limited to the transcript, and at that point, I'd be prepared to make a decision.
I have not heard anything about this witness that makes me think that she would be relevant here. If the underlying charges are, if the underlying actions are not disputed, there are lots of witnesses from whom I think we can hear very important testimony from. But to me, this is.
Commissioner, the underlying acts are disputed. I apologize if I haven't been clear about that, but the extent of the abuse is far greater than what Sheriff Mirkarimi has admitted to, and we dispute that. And this is a witness who has testimony relevant to that.
Okay. Well, let me stop you there. So, other than, I want to set aside the witness dissuasion and that part of the charges. Other than the grabbing of the arm and the bruising of the arm, what other actions are you alleging took place that constitute official misconduct against Ms. Lopez?
Well, I think it's relevant in assessing whether official misconduct occurred to assess the level of abuse that occurred.
But what other abuse are you talking about?
There was pushing and pulling of Ms. Lopez in the house. There was a threat to Ms. Lopez that Sheriff Mirkarimi would use his power in a custody dispute if she tried to divorce him. There were attempts to control her, to control what she ate, to control the amount of money that she got, and this is going to come in through which witness? This is going to come in. This is going to come in through correspondence that Ms. Lopez sent to Ms. Madison. This is going to come through in conversations that Ms. Lopez had with Ms. Williams. And if Ms. Lopez does appear and tries to testify contrary to this, these will be admissible as prior inconsistent statements by Ms. Lopez.
Other views from the commissioners on Ms. Flores?
Well, I think it would be fine to take a look at the transcript and give it what weight we think, and then beyond that, I don't know, we'd have to take a look at if there is any probative value beyond that, maybe as if there's any value as a rebuttal witness for any reason, but right now I can't see a reason how it really ties in to the official misconduct.
I am concerned, I'm sorry, Commissioner Lee.
That's all.
I am concerned that if we allow the transcript in and consider it as evidence, it seems difficult for me to figure out how Mr. Kopp would not have a right to cross-examine that witness. And so I think if we consider it at all, we need to at least have some basis for why we think it's relevant. And I'm not sure that we would be able to base our decision just on the transcript.
Right. Well, one of the other witnesses we have is Nancy Lemon, who's a recognized expert in domestic violence, and her testimony would be that it is relevant whether there have been past instances of domestic abuse because abusers repeat. Relationships follow similar patterns, and if there is past evidence of this, again, it tends to show that it's happening here, and that testimony would come in through the declaration of Ms. Lemon. I mean, I think the time for a lot of these evidentiary objections, whether relevant or on other grounds, is more after these declarations are submitted rather than before, as we try to sort of winnow the witnesses based on sort of going down the list now without seeing what testimony they're actually offering under oath.
I mean, I see your point to some extent, Mr. Keith. I guess my concern is that, I still don't want to get 18 declarations because to me, several of these people are clearly irrelevant. And perhaps for people that are on the line, I can understand, we can defer the decision. But I at least disagree that we want to sort of defer the decision on all of the witnesses.
Again, that's not. I mean, it's what we would prefer if the commission wants to do. Otherwise, that's understandable. We're doing our best is to essentially go through the list and take people out who can be taken out, to see who has facts that can be stipulated to, and that's a work in progress. And certainly, there may be a witness in here who has who has testimony that only takes a 2-page declaration. I mean, we don't want to waste the time of the commission, but it may be that a witness just has a little bit of relevant testimony, we'll get it in, and then we'll be done with it.
Okay.
What I don't want to do is foreclose the chance for a witness who just has a small amount of relevant information to be able to put that information in.
Thank you. Commissioner Studley.
I'm just wondering if we might be able to get a complete picture of this if we set this one aside because it is one of the more complicated ones, go through the rest of the proposed witnesses, see how many are in contention. We may be able to narrow the list substantially if it's a weight and burden issue. And as to this one, because the offer is of existing transcript and it wouldn't take time to develop the initial offer, we might not need to get to it early in this round of decisions. What I'm thinking is that once we have the sworn testimony of Sheriff Mirkarimi and potentially of Ms. Lopez, we may not need this alternative source of information. And that might help us focus on the matters before us. And I do wish the audience would let us proceed, like it or not, let us proceed quietly. This is hard enough.
Thank you, Commissioner Studley. Any objections to that proposal? I think that makes sense. Okay, let's move on to Kathy Gordon.
We may be able to stipulate to her facts, and if not, it would be a very short
Microphone.
declaration. Oh,
Microphone.
I'm sorry. We may be able to stipulate to Captain Gorwood's participation.
Why is it even relevant that she took possession of Sheriff Mirkarimi's firearms on January 14th?
Because it's pertinent to the degree to which Sheriff Mirkarimi was cooperating in an investigation by another law enforcement agency. Law enforcement officers are bound to cooperate in investigations done by whatever law enforcement agency. This was an instance where, and this relates to whether Sheriff Mirkarimi's conduct fell below the standards expected of a chief law enforcement officer. The standards that are expected of a chief law enforcement officer is that he will be fully forthcoming and will respect the investigation conducted by another law enforcement agency. Sheriff Mirkarimi agreed with Inspectors Becker and Daniele that he would turn over his firearms to them in the course of the investigation. What then happened was, through a series of communications, Sheriff Mirkarimi turned over his guns to a subordinate in his own department, so that you had a sheriff who had someone in his own department taking possession of his weapons and keeping them under his control as opposed to being with the appropriate law enforcement
What charge
agency.
does this... You know what, let's take a short recess.
SF Gov TV, San Francisco Government Television.
We are now back in session. I understand the sheriff's deputy is now in the room and has an announcement.
Oh, folks, just a reminder, as for general meeting purposes, we'd like for people to refrain from random outbursts so that the meeting goes smoothly. So we appreciate it if you let people finish what they have to say. Thank you.
Thank you. Before we adjourned, we were discussing Captain Kathy Gorewood, and I believe that Mr. Keith was in the middle of his remarks.
Yes, Commissioner. The other aspect of why the issue of what happened with Sheriff Mirkarimi's firearms is relevant, I've just spoken about the fact that a law enforcement executive is expected to cooperate with an investigation by another law enforcement agency. It's also a problem of an individual who's a batterer having access to his own weapons. And again, this is something that Nancy Lemon, our expert on domestic violence, can testify to as classic batterer behavior.
Mr. Keith, which of the charges in the charging document does this testimony relate to?
That Sheriff Mirkarimi abused his wife. I mean, that aspect of the
whether
firearm.
he turned over his firearms on January 14th is relevant to whether he abused his wife?
It is, and the reason why it's relevant is because batterers behave in a certain way. This is the source of Ms. Lemon's testimony in the criminal action, and we expect to present it here, is that this type of behavior of a batterer trying to keep control of an individual, trying to keep control of his own firearms within his own agency is classic batterer behavior. That is why the testimony is relevant.
Thank you. I think I understand your position. Comments from the commissioners? I mean, to me, not only do I find this testimony irrelevant, I don't. It seems that it would. I mean, it would be. It's such a minor witness in any event that I can't see why we need to hear from this person and how this person is at all probative to the matters that we have at hand. But I welcome the views of my fellow commissioners on this particular witness.
I agree.
Any opposing views with respect to Ms. Gorewood? Okay. Ms. Haynes, we've discussed. Paul Henderson, why do we need to hear from Mr. Henderson?
Mr. Henderson is responsible for coordinating different criminal justice agencies within the city. He would be able to testify about the role of the sheriff having to make decisions on discretionary budget matters and to work with other agencies within the city, and how the existence of a probation sentence for the sheriff affects his ability to participate in those discussions.
And what charge is that relevant to?
That's relevant to whether the sheriff's conduct fell below the standard that's expected of chiefs of law enforcement agencies, which is to not put themselves in the position of making decisions that will affect them in their personal position. Sheriff Mirkarimi is going to be on probation for 3 years. He's therefore going to be making a decision in matters decisions on matters that affect him. There's lots of coordination matters where the sheriff has to make decisions on what's going to happen with offenders, whether they're going to be incarcerated or whether they're going to be subject to something like house arrest, and these agencies have to work together on these decisions. And the concern here is that Sheriff Mirkarimi's ability to make these decisions impartially is going to be compromised. Paul Henderson's testimony goes to what are the actual ways that a sheriff has to interact with other law enforcement agencies in the city, and it lays a foundation for the expert testimony that's going to come in from the experts on the sheriff's ability to discharge his responsibilities in that regard.
So that very well may be. What I don't quite follow is how his ability to perform the job relates to whether he committed official misconduct. I mean, there very well may be an argument that he would be handicapped in his ability to perform his job because of the events that occurred. But I don't think that's before us, and I don't think that's a basis for us to find that he should be, that we should make a recommendation with respect to official misconduct. So please. So at least from my point of view, I don't think any evidence you intend to offer about whether he's going to be able to perform his job going forward is something that is not relevant to our task. Well, I welcome your response and the views of my fellow commissioners.
Well, we disagree. And the reason why we disagree is because there's a question of what kind of misconduct is related to the duties of the office of sheriff. The sheriff has to do a lot of different things within the city and within law enforcement. If he's going to engage in conduct with his wife that has the ultimate consequence of affecting his ability to perform those duties, that demonstrates a nexus with the office that he's performing, and it also shows that he's engaging in behavior that affects his adequacy as a chief law enforcement officer. And that falls below the standard of conduct under the second prong of the official misconduct test regarding the standards of decency that we and good conduct that we expect our officials to engage him, for him to engage in that kind of behavior that so affects his ability to perform in office.
Commissioners, any views with respect to Paul Henderson? Commissioner Liu.
Well, I do think that if the sheriff is taking the position that the misconduct has to relate to something going forward with his official duties, then this evidence potentially would be relevant. If I understand, Mr. Keith, you're trying to demonstrate what the relationship or the nexus is between the alleged misconduct and his performance of duties going forward as sheriff. And I thought I understood the sheriff's position to be that the mayor has to establish that connection. So if that's the case, then I do think this would be relevant if, as Mr. Keith is saying, this witness is supposed to testify about how the alleged misconduct or off-duty behavior potentially could affect someone in a sheriff's position and how it relates to his official duties. So I do see the relevance there.
Mr. Kopp, would you like to address that point?
I think that I think the problem is that this is a very expansive reading of what the duties are of the sheriff of San Francisco. And I understand why the mayor wants to expand those duties so that they can bring in a parade of expensive expert witnesses in an attempt to bury you and us. The problem is the duties of the sheriff of San Francisco are limited. Run the jail and execute lawful court orders. Not much else. So all this extra aspirational goals, while they may be very virtuous, aren't core duties of the sheriff. And for that reason, this witness, as well as almost all the other expert witnesses offered by the mayor, are irrelevant.
So is there no stipulation about what the sheriff's duties are?
We don't need to stipulate. They're in the charter.
So are you having a fundamental disagreement with Mr. Keith about what the duties are, if I understand what you just said?
I suppose so. I read the charter, and I'm going to repeat it when we get to argument on this. And I believe it's 6.102, but I have to go back and check. But there are about 4 or 5 duties that are explicitly spelled out in the charter, and I'll give them to you in just a moment. Only those, nothing more.
Mr. Keith, can you respond to that, please?
Oh, well, certainly the scope of the duties of the sheriff are disputed. Not only are those duties in the charter, they're also contained under state law, because the sheriff is at once an officer of the city and county, but he's also a state officer. He has several duties imposed on him under state law. With the recent realignment that's passed at the state level, there's a lot more discretion that sheriffs have locally with regard to offenders that are being sent back to this jurisdiction. And there's a lot of policy decisions that the sheriff is charged with making, budget decisions that the sheriff is charged with making. And it's our position that if the sheriff's ability to perform those duties is affected, in addition to his core duties, all of those duties are important that he be able to perform well. I mean, the sheriff is an elected official who's expected to meet more than the minimum standard of performing just the duties that are set out in the charter. So we differ very much on that point.
And I apologize if I'm just missing the import of this, but I don't understand why whether he can perform his job going forward is relevant to whether he engaged in wrongful behavior relating to the duties of his or her office, willful in character, including any failure, refusal, or neglect of an officer to perform, meaning it's already whether he can perform any duty enjoined on him by law, to perform. What am I missing?
This is okay. What the portion of the charter that you just cited is the first prong of the official misconduct test. This conduct we consider to be more relevant to the second prong of the official misconduct test, which is the standards falling below the standards. And then the question is, if a person who's elected to an office takes actions that disable him from effectively performing the duties of that office, then that is something that falls below the right conduct that's required under the second prong.
Okay, let's talk about the second prong, because I have perhaps a disagreement with both parties as to what this is supposed to mean, but this refers to the standard of decency, good faith, and right action impliedly required of all public officers, and including any violation of a specific conflict of interest or governmental ethics law. So I don't see this as one standard for the sheriff, one standard for the mayor, one standard for the Board of Supervisors. This is one standard for all public officials. So I don't see why it's, which to me makes Mr. Henderson's testimony all the more irrelevant. I mean,
the argument from us would be that each public official is under a duty to perform the duties of office to the best of their ability, that they're expected to do that. And so you have to look at, well, what are that official's duties of office and how is their ability to perform those duties affected? And that is something that goes official by official. The standard is the same. We still expect all of our officials to be able to perform the duties of office. But then the question is, well, what does the sheriff have to perform?
Commissioner Studley.
Can you explain the handicap or limitation that you think potentially affects the sheriff's ability to carry out the duties of his office? As related to this
I'm going to
witness
defer
offer?
to my colleague on that because she is more, she came prepared to speak to these sorts of issues that relate more to the expert testimony about the duties of office.
Thank you.
Commissioners, first of all, I'd like to back up to the legal point that you were just making about there only being one standard of conduct for all public officials. Actually, under the well-established law in California, these sorts of conduct codes of, professional conduct, conduct unbecoming an officer, immoral conduct, I mean, it's formulated in many ways. But the Supreme Court has always upheld these against vagueness challenges by saying it isn't a one-size-fits-all conduct requirement. It's a conduct that's specific to the office that the person holds or the profession that the person practices. So there are, under this established law, interpreting these sorts of conduct clauses in terms of vagueness challenges, which is being raised here.
Ms. Kaiser, but a vagueness challenge is not the subject of our discussion right now, and I understand I've read your papers, I understand your position on that. If, for example, there is for attorneys or doctors or any other profession a standard of care and a promulgated rule requiring that they not fall below the conduct for lawyers or for doctors or for accountants, then they are held to that standard. My point here is, aside from the vagueness challenge, this appears to refer to a standard for public officials being the the relevant body of individuals. Not that you can extrapolate from the fact that, yes, these standards, when applied specifically to a profession, are can be used, but that this is referring to a specific profession, that is, public elected officials.
The mayor would disagree with that, Mr. Chairman. There is a different standard of conduct imposed on a chief law enforcement officer that is not the same standard of conduct that is imposed on an elected dog catcher for, the very other end of the spectrum. Mr. Mirkarimi did not run for a job that was devoid of these extra responsibilities of a law enforcement officer. He is both elected and a chief law enforcement officer and a chief jailer and a department head who will have to deal with many other department heads. Not every elected public official has that constellation of duties, and we do have experts coming prepared to explain what it is that is inherent in a sheriff's job as a correctional official, as a law enforcement official, as a department head, that sets forth the standards of conduct for that particular position.
Thank you. Questions for Ms. Kaiser or comments from the commissioners?
I'm going to try my question again. What is the offer of proof that you're making about what stands in the way of the sheriff's ability to carry out the duties of the office going forward? For example, is it time, that he will have time that has to be committed toward probation acts, or is it something else? I'm just trying to focus this on what you're saying, I'm calling it handicap. What's the limitation that under which you believe he would suffer, that he would have to follow, that would impinge on carrying out the duties of office? I think it relates to several different witnesses and to a number of the expert witnesses.
Yes, it does, Commissioner. I'm not prepared to give you a complete list today.
Just example.
But for example, a sheriff has to work in harmony and have credibility with other department heads in the criminal justice system. This sheriff would both be on probation and negotiating policy decisions and important, determinations about reentry with the chief of the adult probation department, whose staff member would be supervising this sheriff, and it creates incredible conflicts of interest. It also creates difficulties for other city officials in figuring out how to proceed, whether they can have confidence in this sheriff or not, whether he will, going forward, continue to obey the professional standards that he's already once broken. So conflict of interest is one problem. Another problem is the morale of the office. Being an example of how best to imprison people is going to be very difficult once you've been convicted of unlawfully imprisoning one's own spouse. So a lot of this has to do with the effect of the sheriff's actions on the perceptions of his peers and their ability to work with him as a professional going forward. And there are many duties of the sheriff's office that are affected by his particular conduct and by the sentence that was imposed on him. These are not unconnected items. Like, for example, there's a case, there are a number of cases in California law about the effect of being convicted of possession of marijuana on one's ability to practice one's profession. Invariably, for law enforcement officers, for correctional officers, these people are being terminated, and the courts are upholding the termination because there is a relationship between that criminal act and their duties. At the same time, a real estate broker, the court says there's not a clear connection between that profession and that crime. So we are trying to show that the acts here that are being alleged are in relation to the sheriff's duties and are in relation to the standards of conduct for a chief law enforcement official.
Commissioner Han?
Well, I appreciate your explanation and your comments, and I do think that perception is very important in a law enforcement officer and certainly someone who runs a law enforcement agency. I think the question, Commissioner Herr, would be which witness would be most appropriate to sort of lay that groundwork. I mean, there are several witnesses on these lists, expert witnesses or this particular individual, Paul Henderson. We don't need to hear from all of them, but perhaps hearing from one who can talk about, you know, the value of or the conflict inherent in someone who has been convicted or pled guilty to something who is also a law enforcement officer. It would be valuable to hear how that is problematic, but I don't know that we need a whole list of people to talk about that. So the question is, who's most appropriate? We also have former Sheriff Hennessy on the witness lists. Perhaps he's someone who could address some of that. I don't know. But I think that there are just too many people who kind of fill that category, so maybe we could just come up with one individual who answers those questions.
If I may, I'd like to explain why the different individuals are on the list. That might help you deliberate about what would be most important.
Well, why don't you answer that question first, though?
Yes.
If you had to choose one of these witnesses who would testify about the effect that the sheriff's actions would have on his ability to perform his duties going forward, who would that witness be?
Well, as we understand it and as we've presented it, it's really a two-pronged question. We need to present the factual basis of what the San Francisco sheriff does, and then we would need to present expert testimony about how those duties are affected. And we have presented it as though there are several facets to the sheriff's duties, which we believe, but we are happy to follow your direction in terms of winnowing them down. So it's hard to say, given the many different duties and given both the factual and the opinion testimony that's needed, that we can locate that in one particular person. The intent was to offer Mr. Henderson, to offer Acting Sheriff Vicki Hennessy to talk about the current responsibilities of the sheriff, and in particular to offer Chief Wendy Still to talk about the particular relationship between the Sheriff's Department and probation. We think that that's probative. If you wish for us to narrow down the approach to the question and not focus on cooperation with other city agencies or not focus on the efforts of the probation department and the Sheriff's Department in tandem and why those are now essentially polluted, or why it is that just inside the Sheriff's Department there are innumerable conflicts with the sheriff's duties, we're happy to limit that. But there's no one person who can testify to all of those things. And we do believe they're all relevant and they're all important and they're all worth hearing. And even if the commission finds it to be overkill, we don't know what the Board of Supervisors is ultimately going to conclude when they review the record. And we would ask that the commission err on the side of over-inclusiveness for that reason. Even if you don't want to hear testimony, even if you want to bypass this witness, we would like the opportunity to get this important testimony into the record. We do think it's relevant. We do think that there are decision makers who would like to consider it.
Other questions for Ms. Kaiser? I must say that I think all of these witnesses who are talking about the mayor's impairment or alleged impairment to perform the duties going forward are not relevant to what we are tasked to do, which I think is a narrow fact-finding investigation as to whether conduct that has already occurred is official misconduct. And getting testimony about the relationship among various agencies, getting testimony about the duties of the sheriff and whether he can perform them or not, I don't see the relevance, but it appears there is disagreement among the commissioners about that, and if there is, I think we should discuss it, because I think it greatly affects the scope of the testimony.
Well, as I read the briefs, I believe that the mayor was proposing to introduce this evidence because of the argument being made that the misconduct, if it occurred, was not in relation or was not connected with his duties as sheriff, and that what the mayor at least argues in his brief is that, and concedes that there should be some relationship, and cites a number of California cases of law enforcement personnel who were terminated because of, for example, speeding violations. And the court talked about the fact that a law enforcement official has a special set of duties that a violation of the law which might not affect a non-law enforcement officer. And that's what I understand this testimony is in for, is to say, to rebut the argument being made by the sheriff that these acts, if they occurred, are not related to his duties, and therefore he does not fall under the grounds of being suspended or put out of office because of, quote, official misconduct. But I do think I agree with the statement that it seems to me you ought to be able to put that in by a single declaration or two at most, setting forth what they are, and I think there's fair grounds of cross-examination as to whether or not the conclusions reached are correct. That the mere fact that somebody is on probation, or the mere fact that somebody may have pleaded guilty to false imprisonment somehow or other disables him or her from operating as a sheriff.
Absolutely, Commissioner. And there's no question that we carry the burden of proof on that point, right, and that just by saying it, that doesn't make it so. We want the opportunity to bring the testimony. We want the opportunity to give you the materials to reach an informed conclusion about whether the allegations are right or wrong. Just saying that they are right doesn't make it so. But the other problem that we have is a problem that you all discussed a little bit earlier, which is avoiding the problem of hearsay and making sure that our testimony is well-founded in personal knowledge for the fact witnesses and in expertise for the expert witnesses. If we only have one witness, we will not be able to have a witness who satisfies the evidence code and who meets the highest standard of presentation that you would like to see. And that's part of the reason why we've been very thorough, but we think it's good. We think we're trying to give you a thorough, solid, sound record on which to base your decision. And that's been the impetus for creating these lists. It's not an attempt to snow you.
Sure. And I appreciate that, Ms. Kaiser, and I certainly would not suggest that you are trying to drown us in paper or anything like that. But this procedure does contemplate a hearing taking place as soon as 5 days after the official charges. And I think one of the reasons that's contemplated is because the elected official is suspended without pay during the time that the Ethics Commission and the board adjudicate the matter. So I find it hard, to me, I find it hard to believe that we need to have witnesses sort of talk about every single element of how the sheriff can or cannot do his work, when this is something that we should be able to do, at least in the first instance, within 5 days of charges. Commissioner Selby.
Yes, I found Commissioner Rennie's comments about the issue that this might go to be convincing. I also see this as very different from the testimony of Ms. Flores, which does run the risk of taking us into very distracting and unproductive terrain if we don't really need it. I think while I'd like to have as few of them as we really need, I think that I, for one, and others may disagree, would be more open to receiving these declarations, allowing the sheriff's representatives to counter or investigate them, to narrow as much as possible by their stipulations beforehand, and not to delay in order to get a lot of them. So it may be necessary to be selective if our scheduling says this is when we are ready to go forward, because for a variety of reasons, it's only fair for us to move toward resolution on this. So I wouldn't delay for the purpose of securing more of these kinds of offers of these declarations. But on balance, I would narrow rather than exclude altogether. I think there are some points that might be, that are important to understanding whether they fit the definition in the first place. And my own effort would be to try and slim the list and schedule things so that we move forward and the city can pick the ones that are the most valuable or execute them so that we can stay on track.
Okay, so it sounds like, having heard from all the commissioners on this witness, that we think Paul Henderson, the majority think that Paul Henderson should come in or be permitted at least to submit a declaration. Michael Hennessy. Michael Hennessy was on the list of individuals that we had identified at the beginning, so I don't think there's a dispute about him. Mm-hmm. Acting Sheriff Vicki Hennessy, unless the parties want to be heard on Michael Hennessy.
We can get a declaration from Acting Sheriff Hennessy. I don't know. I don't think we can. We certainly can't compel the retired sheriff to give us a declaration. The point of the testimony is to just lay out the duties of what a sheriff does, and we can get that just as easily from Sheriff Hennessy, so we can drop Michael Hennessy from our list.
I'm sorry, you can drop Michael Hennessy?
We can drop Michael Hennessy from our list and just use Vicki Hennessy for that testimony.
Mr. Kopp?
Yes, I expect that we would probably want to at least submit a declaration from Michael Hennessy, probably addressing different points, such as one would be the fact that many deputy sheriffs have suffered criminal convictions during his 32-year tenure, and that was not seen to be official misconduct that required those deputies to be terminated. So that's one point that I don't think the mayor intended to introduce. And I think that retired Sheriff Michael Hennessy may be able to offer other pieces of fact information that would help the commission in reaching its decision. We haven't obtained one at this point, but we think that we can obtain one from him.
Okay, and Mr. Keefe, you indicate in your witness list that you expect him to testify about communications with the sheriff, which I could see coming in. Would you rather have Michael Hennessy than Acting Sheriff Vicki Hennessy, if their testimony would otherwise be overlapping, and Michael Hennessy is going to speak to statements made by Mr. Mirkarimi?
I think, given the burden of preparing a declaration, I feel that it's more appropriate to place that on somebody who's currently working as sheriff as opposed to somebody who's retired. So we would just use Vicki Hennessy.
Please, we're having a pretty good run there of silence. So if we could keep that up, that'd be great. I know it's a long night. Commissioners views on Vicki Hennessy. Is there an objection to hearing from Ms. Hennessy? Do we think we need her testimony?
Well, I'm sorry, Mr. Keith, did you say her testimony would or would not overlap with Michael Hennessy's testimony?
But my concern is our being able to get a declaration from the retired sheriff.
I see.
Yeah.
Mr. Chair, is your objective to choose one or the other? I'm not sure what question is on the table.
My question is whether we need Acting Sheriff Vicki Hennessy. It sounds like, Michael Hennessy was listed as an expert witness by the sheriff, and we can address that later. But if he's going to be testifying, do we need what sounds like overlapping testimony from Vicki Hennessy, whether or not you can get a declaration from Michael Hennessy?
On that point, we didn't list the retired sheriff as a witness who was going to testify to every responsibility of the sheriff's department. We listed him as a witness who was going to testify to the transition and as to statements that Sheriff Mirkarimi made to him.
Surely he could, though. He was the sheriff for a long time.
He could, but again, getting a declaration from a retired city employee is not always easy.
Mr. Keith, I'm sorry. You started off by saying you were going to be able to submit a declaration for all your witnesses, and that's what you wanted to do, was proceed by written declaration.
Yes.
Mr. Hennessy is listed as a witness on your witness list.
That's right.
And you intend to submit a declaration with respect to some testimony, some matters, right? Otherwise, how would you get him in if your intention was to submit declarations for all your witnesses and he's on your witness list?
I clarified earlier that we can submit a declaration from the mayor, all current city employees, and those witnesses who are no longer with the city who are willing to do it. From our part, we would rather use a current city employee if they're going to be put to the burden of preparing a declaration and submitting testimony. That's the preference in that regard.
I see.
If I may add, an important reason to have Vicki Hennessy, just from the expert perspective, which you can see is part of...
This mic, please. Thank you.
I'm sorry. Part of the importance of Vicki Hennessy's from just the expert view is that the experts will be working with her as the current sheriff to understand, what they will be giving their opinion about. And so her testimony will serve as a foundation for a number of the experts. And we can coordinate that with the acting sheriff in a way that we cannot coordinate with the retired sheriff.
Mr. Chair, are you trying to have one or the other? Would it be a problem if the city offers a declaration from the acting sheriff and the sheriff offers a declaration from the retired sheriff?
I don't think it would necessarily be a problem, but what I'm trying with the exercise that I think we're going through here is to try to narrow down redundant witnesses or witnesses who are irrelevant. And to me, these two are redundant witnesses. So I guess what I'm saying is I would be in favor of excluding Vicki Hennessy because I think her testimony is going to be redundant to what we are going to hear from Michael Hennessy. And if the mayor needs to have Michael Hennessy come in, he's probably going to be here anyway in light of what we've heard from the sheriff, I think we could save time and effort by actually having only one witness testify about these issues. But if other commissioners disagree and we think we should have a declaration from both, I can see that view as well. So maybe we should...
Do we have to decide that right now?
Well, I think what we're trying to do...
I know what we're trying to do, but...
I think we should, yes. I think we should decide whether or not someone is going to come in by declaration or not, because otherwise...
Well, I agree with that. But we may find, we're trying to narrow down the list of witnesses, and that's fine, and I think the fewer the better. But we may find that in the course of hearing witnesses, there's some additional information that we're going to need, and we may want to call in a witness that we didn't initially think we needed. That's all I'm saying. And can we make that decision further down the line if we feel that there's information lacking?
Commissioners, if I may be heard on this question.
Yes, Mr. Wagner.
David Wagner for Sheriff Mirkarimi. So as to Acting Sheriff Vicki Hennessy was a political appointee of Mayor Lee. So, you know, to the issue of whether they're redundant, Michael Hennessy can provide testimony that actually relates to the charges. It's not at all clear, and it hasn't all been, it's not at all clear how Vicki Hennessy, her testimony is in any way relevant to the charges. On page 4 of the mayor's list of fact witnesses under Vicki Hennessy, it says that she'd testify about the role of the sheriff. The role of the sheriff, again, as the conversation we just had about Paul Henderson, that's not relevant to the actual charges. And if I may also say, as to the actual charges, there are no actual counts. It's 9 pages of a narrative statement. There's no counts. So we would request respectfully the production of a bill of particulars as to what exactly the charges are, so that we can actually defend against them, and so that the mayor and the city attorney can say exactly which charge each of these witnesses allegedly would testify to.
On Vicki Hennessy, I am fine with the suggestion of Commissioner Hayon. You know, the prejudice of having Vicki Hennessy is not high, I don't think, in some respects, if she's going to testify on the matters that are listed herein. I, for one, agree with Mr. Wagner. I don't think it's relevant, but I'm in the minority on that. So I think if the mayor wants to submit a declaration for Vicki Hennessy, we should allow it, and we can evaluate further if we need additional testimony. Is there any objection to that? Commissioner Studley.
No objection. I'd rather have both, because I think it would help me understand what the differences were than to have one and guess what the other would say or argue about what the other one would say. I think it might illuminate the differences if there turn out to be any between the two of them.
Okay. Next is Lieutenant Michelle Jean and/or Inspector John Keene. So is that really an and/or is that an or?
We don't need to call either of them.
Okay, great. Next is Mayor Ed Lee. I think we've discussed him. Eliana Lopez, we've discussed her. Ivory Madison, we have discussed her. Abraham Mertens, I think we've discussed him. The sheriff, we have discussed him. Chief Wendy Still, so I guess we're on number 16, Mr. Keith, or Ms. Kaiser. Why do we need to hear from
We need to
Ms.
hear
Still?
from Chief Still to provide a factual basis about how it is that the Sheriff's Department interacts with the Probation Department, but also particularly how the Probation Department interacts with probationers, which is not something that, you know, most officials of another ilk will be able to speak to. I think it's through that some of the conflicts that are inherent in this situation and the relationships between the sentence and the sheriff's duties will become crystallized. And again, we just need to put in the fact foundation for that. We can't just tell you it is so without providing testimony that it is so. I'd also like to point out, by the way, as I'm sure you've noticed, Wendy Still shows up both on our fact witness list and on our expert witness list. She is testifying in 2 entirely different capacities. I'm happy to address that when we get to discussing experts, if you wish.
Okay, thank you. Commissioners' views on Wendy Still?
Was it your intention to present her testimony by declaration?
Yes, we're happy to provide everyone's testimony by declaration who will cooperate with our efforts. And if I may just make the point that by doing this by declaration, we're really shouldering the burden of the witness list. We're asking you to review the declarations, but we will, on your schedule, do what we need to do to get the declarations ready for your review. And we do believe that it will be easier to make some of these decisions once you've seen the testimony and understand why it's being offered than it is to do before you've seen it. So I really think that the burden of doing that and including more witnesses is going to fall on our shoulders more than yours, and we're willing to shoulder that burden to get you the evidentiary record.
And I do appreciate that. I think for me the concern is, regardless of the work that's required to get the declaration, I think most declarants, to the extent we're going to really be valuing their testimony, are going to be cross-examined. So, I think that I don't want to be falsely not falsely persuaded, but I don't want to be persuaded that this is going to really reduce the burden if we're going to have to hear from all of these people live in order to truly evaluate the written declaration, is my
I think my response to that would be that at the point that you see the opening declaration, you can still put the witness aside. You can still decide that witness is irrelevant and does not need to be subject to cross-examination or part of the live hearing. One does not inexorably follow. I think this procedure that you're going through right now can be repeated or maybe done best on the basis of the actual declarations to see what the witness really does offer and how it fits in.
Mr. Kopp or Mr. Wagner, do you have a what do you think about that procedure?
In theory, that sounds fine. That doesn't address our concern that witnesses such as this Chief Wendy Still are irrelevant to the inquiry. And she's, in our view, she's not going to add anything to your task of determining what the facts are of what Sheriff Mirkarimi did and whether or not that was official misconduct. I just think they're ranging very, very far afield. So I suspect if you allow them to put in a declaration, we will be objecting to its admission in its entirety. As far as the procedure goes, that's probably better than bringing the witness in, putting them on the stand, and having us object on a question-by-question basis.
Thank you. So then I think our task tonight then should be to eliminate those witnesses who we truly feel are irrelevant and from whom a declaration is very not likely or very unlikely to provide us with relevant information. To the extent that we think it's a close call or that there's disagreement, I think we should invite the declaration and evaluate the declaration once we receive it. Do the commissioners have views as to where Wendy Stills falls on that spectrum?
Well, to me, it seems that she's, again, in that category of the pool of people we had just been discussing about whether it relates to his job duties or not, whether a charge of misconduct would relate to his job duties. And I think I understand the mayor wanting to perhaps also expand on that a little bit, but I think that's generally the category that I see it in, about how it relates to the job duties. So, I mean, I would think that that's probative given the sheriff's position that the charge of misconduct must relate to the job duties.
Okay. Any other dissenting views to that? Okay, so the excluded fact witnesses then are either Inspector Becker or Inspector Danielle.
I think they were going to stipulate on Dempsey.
Right.
Stipulation.
Jan Dempsey, we expect a stipulation from the parties. Captain Kathy Gorewood would be excluded.
And Christina Flores?
Christina Flores, I think we deferred. And Michelle Jean and Inspector John Keene. The others, to the extent that we think they should, to the extent they would like to submit a declaration, we'll review the declaration and make evidentiary objections at that time. Expert witnesses. Who will address the experts for the mayor? Ms. Kaiser. This is a lot of experts for this issue. Based on additional, I know that you submitted this prior to some of the briefing. Has anybody become unnecessary in light of recent briefing and your investigation, or do you still intend to call all of these experts?
We would still intend to call these experts, and I can do a brief explanation of why, if that would be helpful.
Yes, please.
Okay. Mr. Giannacco, the first witness, to go to Sheriff Mirkarimi's point that there have been many other law enforcement officers in the Sheriff's Department who have been disciplined but not terminated on the basis of criminal conduct. Mr. Giannacco is an expert in discipline at the LA Sheriff's Office and with law enforcement nationwide, actually. He's a consulting expert. So he could speak to that very issue, and he could speak to how it is that the sheriff should be treated under his own disciplinary system, essentially. So he's being offered for that purpose. Chief Lansdowne is the chief of police in San Diego. He's being offered as a chief law enforcement officer, and particularly a chief law enforcement officer who teaches an ethics course at the Professional Association for Law Enforcement Executives on law enforcement ethics for chiefs. I think his testimony is going to be very germane to the standard of conduct expected of a chief law enforcement officer, and he has the expertise to give it.
Okay, we've heard about Ms. Lemon from Mr. Keith earlier.
Actually, may I just add one thing about Ms. Lemon?
Sure.
She is a nationwide domestic violence expert, and she's here actually, she's on this list because she can offer important testimony about, was this really just about a pinch on the arm? Was this really just about a decision to turn the van around and not go to the restaurant? Or is this something more significant? Again, these proceedings are not about a plea deal. These proceedings are about the actual conduct and what the conduct means in terms of the public official, the acts of the public official, and the relationship between those acts and the public official's position. So it's our position that we need to be able to explain his conduct and what it means and what it entails. And Ms. Lemon, by the way, was being offered in the criminal case and would have gone and served at trial for that exact same purpose, to show that there is more content than what Sheriff Mirkarimi so far has been willing to admit. We think she's important for that reason.
Okay, we've heard about Wendy Still. Elizabeth Tarchi is an assistant DA, and what expertise would she be offering us?
She is not, although she was the prosecutor actually in Sheriff Mirkarimi's case, and that case remains ongoing as long as he's on probation and being supervised. She is not coming to speak to the specifics of his case. She's coming as the chief domestic violence prosecutor in the DA's office to help you understand what that plea deal meant and what the sentence means and what it doesn't mean that they dropped the other charges. You have seen in the briefing some assertions that, well, the other charges, the other facts now are conclusively not proven. They've been set aside. That's actually not what the plea deal means. And again, it goes to our ability to show you what the actual conduct was, and that the conclusion of the criminal proceedings is not something that binds you, and also to make sure that you don't misunderstand what its import is. As many civil lawyers or other volunteers don't necessarily know, myself included. I've been getting an education. And if I may speak to Chief Still on the expert list, please, just briefly. Yes. She is not coming actually as an expert on the probation issues. Chief Still ran California prisons for several decades, and she's coming in to speak about the special responsibilities and duties inherent in running a system that locks people up, and how Sheriff Mirkarimi's conduct affects that particular responsibility.
Please.
And there's one more.
Beverly Upton.
Yes, Beverly Upton can speak to the damage that the sheriff has done in terms of the community relations between law enforcement and the many nonprofit agencies that have worked really tirelessly, frankly, on this issue, and worked tirelessly with many city agencies, particularly in the wake of a truly brutal and horrifying murder a number of years ago that catalyzed the community, both in terms of the government and the private agencies, to work together.
I'm sorry to interrupt you, Ms. Kaiser. Please, we are trying to get this done. If you guys could please keep quiet and let these proceedings go forward, you really would help all of us. Thank you.
We take the position that one of the sheriff's duties is to work effectively with the community on an issue of great importance to the community, and we believe that his ability to do that is significantly impaired by his domestic violence, and Ms. Upton is being offered as an opinion witness to speak to that, and she has the firsthand expertise to do that.
Commissioner Studley.
I have a question about expert number 5, Ms. Aguilar-Tarchi, as to whether someone who has played a part in the actual proceedings up to this point can appropriately serve as an expert on the issues that are being offered. You folks who do this all the time, I think, know better what the expert standard appropriately would be. I'm not sure whether that applies to Chief Still. It seems more specific as to the prosecutor.
Mr. Kopp, would you like to address Commissioner Studley's question?
Well, actually, if it's okay, I'd like to express our objections to these witnesses, and I'll certainly get to that particular witness, because I think that's only one of many who may have already demonstrated that they're an interested participant here. I mean, maybe I should start by going backwards. Ms. Upton was a vocal critic during the criminal prosecution, and if I'm not mistaken, when we were here last month, she came up and gave public comment against Sheriff Mirkarimi. So how anybody thinks that this type of a biased witness should be allowed in a proceeding such as this is beyond me. Ms. Aguilar-Tarchi, and I apologize if I'm saying the name wrong, she was the prosecutor on the criminal case, and she's going to come up here and educate people about how dismissal of charges doesn't mean anything, they're still true?
Mr. Kopp, so I understand your objection to whether the witness is useful and has evidence that's not going to be completely impeached by the fact that she was involved. Is there a legal basis to exclude her on that grounds?
Which proposed expert? Are you speaking of Ms. Aguilar-Tarchi?
Does the fact that she was the prosecutor as a legal matter mean that she must be excluded as an expert?
There's no probative value to her proposed testimony. Domestic violence prosecutions and how these cases are resolved, how is that relevant to the determination that you've got to make as to what the conduct was and whether or not it was official misconduct? How the criminal case was resolved is irrelevant to the inquiry. You can determine the facts, and then you can decide whether or not this was official misconduct. So, yes, there is a legal objection to that witness's testimony.
Well, Mr. Kopp, will you be arguing the effect of the plea deal or what it means to have certain charges have been dropped? Are you going to be arguing any of that?
What we intend to argue is that the misdemeanor charge upon which Sheriff Mirkarimi was convicted in and of itself does not constitute official misconduct. We don't intend to argue the effect of the dismissal of the other charges. With respect to the incident that was underlying for the criminal prosecution, we intend to argue that grabbing his wife's arm during this argument also wasn't official misconduct. And that's it. And that's what this inquiry should be about.
I mean, to be fair, your briefing, if I'm recalling correctly, did suggest that, try to suggest that the dismissal of the other charges means that they didn't occur.
Well,
but that's what I'm not hearing that from you right now.
Correct. And to the extent that we did not mean to suggest that. We do not argue that the dismissal of the other charges means that nothing happened. I think that we'll be able to prove that what happened is what I've been telling you all along, but we don't intend to argue the legal effect of the dismissal of the other charges. That's correct.
Ms. Kaiser, in light of that statement, and I can understand your confusion prior, does that obviate the need to have Ms. Aguilar-Tarchi?
I'm sorry, I think this is the only microphone that's working. If we can reach appropriate stipulations with opposing counsel, I think that might obviate the need. As you've noticed, what he says in his briefing and what he's saying right now to the commission are different. If we can nail him down in a stipulation, and it could be either we don't agree or we do agree, but at least the subject matter would be firm, then we may be able to forego Ms. Tarchi. What I'm concerned about, though, is this sort of repeated assertion that what's at issue here is a guilty plea to a misdemeanor. That is actually not what's at issue here. What's at issue is the wrongful behavior, not the guilty plea. The guilty plea is an admission of criminal guilt, but it is not an element of official misconduct and shouldn't be mistaken for the true ambit of the inquiry here. We want to get to the behavior, and we can't agree to be limited to what Sheriff Mirkarimi was willing to admit to.
And I don't think anybody is suggesting that you would be. And what I took your initial argument to be was that you needed this because the sheriff was suggesting that the dismissal of the other charges was actually probative evidence that they didn't occur. But if that's, I mean, and he stipulated this in open court or open session in front of the public that that's not what he's going to say, why do we still need Ms. Tarchi, assuming you could get a written stipulation on that?
We need Ms. Tarchi to also explain that false imprisonment as a matter of law is not coextensive with turning a van around from going to the restaurant to going home, that would not satisfy false imprisonment, yet the parties stipulated that there was a factual basis to that charge. So there's a discrepancy between what Sheriff Mirkarimi is saying and what legally can possibly be supported by his plea deal. We would like to have that in. Please understand this in the context that the only statements of Sheriff Mirkarimi's that we've had access to are the statements in the media. We don't have stipulations. We don't have an interview of Sheriff Mirkarimi to look at. He won't talk to us. We need to be able to bring witnesses who are responsive to the arguments we've heard him make elsewhere. If he's going to change those arguments or those positions or explain them more fully before the commission, we're prepared to respond to that. And if that means we don't need to bring a witness, we're prepared not to do that. But right now, we're not in a position, frankly, where we can give that up because we don't know what it is that we're going to encounter.
Can I ask you one question of clarification? Isn't it your position that the guilty plea to false imprisonment standing alone is sufficient grounds for the mayor to have acted finding official misconduct and suspending the mayor?
Suspending the sheriff.
I mean the sheriff, yes. Thank you. It's getting late. But isn't that one of your positions, that that standing alone is sufficient? And then you say, but if it is, assuming it isn't, we want to be able to prove the rest of it.
Yes, we do believe that standing alone, at least the conduct that was adjudicated in the context of a man filling the office of sheriff and being sheriff-elect and being a member of the Board of Supervisors, we do think that that's sufficient to state a cause of action for official misconduct and to lead to his removal. It's not that that is insufficient somehow. It's that our case is not limited to that. And we also don't agree with the position that it is somehow without content, that, for example, the argument that it's not a crime of moral turpitude really relies on a Ninth Circuit case about whether it's even possible to commit without moral turpitude for purposes of deportation, because an offense that can be a crime of moral turpitude can lead to deportation in some cases. Now, the very fact that it's possible to have committed it without moral turpitude isn't very relevant in this case, where what's at issue is the actual behavior. And that actual behavior, frankly, under the case law, is an act of moral turpitude. What we don't want to do is be hemmed into these sort of formalistic arguments. We always want to be able to present you with the actual conduct that is the basis of the charges, not an empty form.
Thank you.
Perhaps
Commissioner Studley.
starting in the affirmative, speaking only for myself, I would find it helpful to hear from the first and/or the second expert witness, because I do feel that we will each be asked to determine something about the standard of decency, good faith, and right action required of public officials. And it appears to me that this testimony would be helpful to me. If Ms. Lemon, Professor Lemon, is the primary domestic violence witness, that is a witness from whom I would like to hear. I think the issues related to Ms. Aguilar-Tarchi, whether or not there's a legal answer about whether she could be an expert for us, I think the best evidence is what we will get from the fact witnesses themselves, and I'd be prepared to put that one aside unless and until we feel that we have a question that would help address, if that's permissible. And that, for me, would leave whether there's something that Chief Still would add, and I think the comment about Ms. Upton as an expert witness is well taken.
Which comment?
The sheriff's comment.
Okay, so in your view, you would hear from experts 1 and 2?
And 1 and or 2, if the mayor really thinks they speak to different issues. I see there's some effort to say that that they have somewhat different focuses in what they would be speaking to.
Okay, so 1 or 2.
Number 3.
And that's...
I haven't responded as to 4, 5 not now, and 6 no. And I've also wondered, I don't know the answer, whether we have the authority to page limit declarations, just in terms of providing some clarity and manageability. You would know better, you and the other litigators would know better whether that's an appropriate
so one thing with
standard.
Thank you, Commissioner Studley, and I echo a lot of your views on this. One bigger concern, though, that I have with experts over percipient witnesses is that experts typically are paid by the party, and if we defer ruling on experts who we think are not relevant, that will lead to the defense having to, in all likelihood, at least as a protective measure, hiring experts to offer testimony on the same issues. So I, for one, am less willing to delay the decision about the relevance of a witness when it comes to an expert than I am when it comes to a percipient witness. Mm-hmm. I share your view on Ms. Aguilar-Tarchi. I don't think we need her now. Same with Ms. Upton. To me, Chief Still is duplicative to Chief Lansdowne. Chief Lansdowne experience seems more relevant to what we're dealing with, which is a local issue rather than a CDCR state issue. So, as of now, my view would be at most we hear from 1, 2, and 3. But again, I welcome the views of my fellow commissioners.
Well, I would like to know, generally speaking, when you have an expert witness, you list what opinions that expert is going to express so that the other side can prepare itself with counter. And I haven't heard from you as to any of these experts that we're talking about now, not Ms. Upton and the other who I agreed that I don't think we need to hear from. But I would like to know what specific opinions are you going to ask these experts to provide to the commission, and how do the opinions say of this first expert, Janako, how does that opinion differ, or how is it different from what you're going to get from Chief Lansdowne and from and Wendy Sill? So why isn't one of them sufficient? And tell us what the opinions are, and we can decide whether or not they really help us at all in preparing a hearing record and sending it on down to the Board of Supervisors.
Thank you, Commissioner. The witnesses are sort of based at or aimed at just particular subject matters. The first one is aimed at law enforcement discipline and the consistency of treatment between this law enforcement officer and other law enforcement officers who have committed crimes. The second witness is about being a chief law enforcement officer and the ethical considerations that go with that. The third one, domestic violence. The fourth one, not running a statewide prison so much as what it means to administer the jail, to be in charge of an entire jail apparatus. And it's analogous to a criminal prison. It's just at a local level. So she can bring us that expertise. So we're giving just a number of topics that relate centrally to the sheriff's duties.
But how are any of those opinions relevant to the issues in this case?
They are going to set forth the standards of professional conduct associated with the position of sheriff in all of those regards. Again, it's a multifaceted position. There are many different responsibilities. The second prong of the official misconduct definition goes to the standard of professional conduct, and we've assembled a list of peers of the sheriffs who can speak to those conduct requirements from the position of being a peer of the sheriff, and that is the legal test associated with the definition of a right conduct standard. In terms, I do want to respond to your question about why haven't we provided a list of opinions that these experts have. Frankly, part of that has to do with the very tight schedule we faced since the last hearing, a month ago, where we've briefed all the substantive issues and other investigative issues as well, put together all of our fact witnesses, and found and listed for you all of our experts. I have not had time yet to work extensively with each expert to find out what their opinions are. It's not actually a matter of I have a list of opinions for them. It's a matter of they have a list of opinions for me. And I needed to know that they had the qualifications and that they were willing to participate. That's more or less what I can tell you right now. And our attempt to indicate the subject matter was a way to signal to the sheriff, who we believed also did have a rebuttal deadline, what the subject matter areas of the witnesses would be.
Thank you, Ms. Kaiser. Other questions for Ms. Kaiser on the experts? Mr. Kopp, I would invite your response, particularly on the on the first few witnesses that we've discussed.
Well, sure, but what I just heard was that the mayor is proposing these expert witnesses without knowing what their opinions would be. How am I supposed to respond in any meaningful fashion to that?
Well, you can respond to whether the topics. What I'm curious about are whether the topics are even merit expert testimony at all.
No.
And so, well, but you have to explain that, which is what we're asking you to do.
I'm sorry. No, I do not think that they merit exploration because, again, I don't think it goes to the core inquiry here. Was the conduct of Sheriff Mirkarimi related to his official duties, which are narrow? So I don't think that a witness who has expertise in whatever happens in Los Angeles is going to help this commission arrive at a recommendation. I don't think that this chief in San Diego is going to offer anything that's going to help your determination. I certainly don't think the domestic violence expert has anything to offer. I understood the mayor to just argue that this witness is going to be able to tell you that there was more conduct, more domestic violence conduct committed by Sheriff Mirkarimi that he was willing to admit to. So apparently she's some sort of clairvoyant as well as being an expert witness. That's just not going to help the inquiry. It's a fact inquiry. It shouldn't be an opinion inquiry. So I don't know if I answered your questions on those three witnesses. I'd be happy to try and add.
Do the commissioners have questions to Mr. Kopp with respect to any of the other witnesses or the three that were identified? Thank you.
I'm sorry, may I just speak briefly to the issue of Beverly Upton, or would you like not to hear about that?
I don't have any questions about her, but if the other commissioners do, then I would invite them to.
I don't have any questions.
I don't think so.
Thank you.
Please.
Excuse me.
That is exceptionally rude. And you know, is there a officer outside?
That's the limit.
Yeah. If you could stay, and if there are people who are making rude comments during our attempt to conduct these proceedings, if you could instruct them to leave, I would appreciate that. Thank you. Are the commissioners in agreement that we do not need Beverly Upton?
Yes.
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 Are the commissioners in agreement that we do not need Elizabeth Tarchi?
Yes.
Yes.
What about Chief Wendy Still?
I'm in agreement that we don't need her.
As an expert?
As an expert.
Any
No.
dissent?
No, I mean, it sounds like we're going to hear about running the jail system here anyway, so I don't think we need Chief Still for that.
Do we think we need Nancy Lemon with respect to domestic violence?
I would like to hear from her.
Yes, so would I.
Good what?
I would like to hear from her.
Yes, I would as well, and as well, I would also like to hear from either expert number 1 or 2 for the reasons articulated by Commissioner Studley.
I agree, 1 or 2, not both.
Right.
I agree with that as well. Among the two, well, maybe we can ask Ms. Kaiser. Ms. Kaiser, if we were to exclude one or two, do you have a preference, given that it appears they are somewhat duplicative?
I would like to be able to explore with the witnesses who has a better foundation to give you non-hearsay.
Well, it's an expert, so
solid. I understand, but opinions based on solid expertise and experience. I don't know. I would like to have a witness who can speak to both of those topics, and I don't know which one will be better qualified to do that.
Okay.
I would find that acceptable, to let the city choose.
Any objection? We should make sure to have a timeline for when those disclosures are made, but I find that acceptable as well. Okay, next we have the sheriff's list of experts. I think just includes.
Mr. Chairman,
Yes.
there's 2 additional expert witnesses on the mayor's list under tab 14.
Supplemental list. Thank you.
If I may go right ahead and offer, I'm happy to reserve Mr. Sinclair as a potential rebuttal witness. He also is responsive to arguments that have been circulating about rehabilitation and accountability and things like that. He can speak to that, but until those arguments are made, I'm happy to put him aside.
Mr. Kopp?
I'm sorry, which witness was this?
Hamish Sinclair.
You know, I don't have before me the proposed testimony, but yeah, I'm going to let Mr. Wagner address this, please.
Okay. Mr. Wagner.
We object to Mr. Sinclair's testimony in any fashion, certainly as an expert. Mr. Sinclair actually made public statements that were very harshly critical of Sheriff Mirkarimi, similar to Ms. Upton and Ms. Tarchi. Mr. Sinclair has already offered his opinion as to the underlying issues in this case, and on that basis, we would respectfully request that he not be included as an expert or otherwise.
Mr. Wagner, so will you agree then that you are not going to be offering affirmative expert testimony on the subjects listed under Hamish Sinclair
That's
in the
correct.
mayor's supplemental list? Okay. Well, then I guess there would be no need for rebuttal if there's no offered expert testimony on that subject.
We're concerned about Sheriff Mirkarimi's own self-description as fully rehabilitated, fully having accepted accountability, being, coming to you from the perspective of restorative justice, having already traversed that process. We don't agree with those statements. We've heard them. Again, in the media, we don't know if we will confront them in the case, and that's why I would like to, I'm not comfortable saying the issue won't come up. It may not come up with an affirmative expert on their side, but we may need expert testimony to rebut some of the sheriff's own testimony based on what he said to the media.
Comments, views from the commissioners with respect to Mr. Sinclair?
May I also just make one overarching point, which is normally experts come to cases with backgrounds. They don't promise to be neutral observers. Some people in this particular case have very strong opinions. Whether or not they're biased generally goes to the weight that you give their opinion and is not usually just in civil practice. The normal process is to determine whether they have sufficient expertise to be heard, but then whether or not you believe they are biased or unable to evaluate the issues clearly would go to the weight of their testimony. I just wanted to clarify that that's standard practice. It may not be what the commission decides to do here.
Comments from the commissioners with respect to Mr. Sinclair. Ms. Kaiser, Mr. Sinclair was offered as a supplemental subject matter expert. So that means that was based on seeing the expert disclosures or the witness disclosures, right, of the mayor. No?
No, I believe the timing was such that certainly our expert disclosures predated their expert disclosures. The only reason it's supplemental, actually, is not in response to anything we saw from the sheriff. It had to do with the very short timeline we were working on and just difficulties in reaching witnesses and, making sure that they would be qualified and would speak to the issues. It was simply an administrative difficulty. And that was the case both for Mr. Sinclair and for Sheriff Smith.
I, for one, do not see the relevance of Mr. Sinclair. I don't see how this is going to help us make our decision. Is there any dissenting viewpoint, Commissioner Liu?
No, I mean, I would agree with you because I think, we're here to determine the facts as they happen and how that relates to his job duties, possibly, or not, and not necessarily to determine his conduct, his post-sentencing conduct. So I would agree that we don't need to hear from this expert.
Sheriff Smith, Ms. Kaiser, would you like to speak to Sheriff Lori Smith?
We believe that she is also expert, this time not on discipline and not just on chief law enforcement ethics, but she'd be able to speak to the duties and the relationships of a Bay Area sheriff in a large municipality and what it takes to serve in that role. Again, it's a different focus. These all go to the duties of the sheriff. I do not believe that any of these, frankly, are duplicative, but to the extent that you would like us to narrow down the list, we'll do what we can to combine. I think the most that I can say is perhaps we should put her in the list with the 1 or 2, and maybe she should be 1 or 2 or 3. And we can talk to that group of witnesses and see who can best represent the positions we'd like to offer.
I have no objection to that.
That's fine.
Fine.
Okay.
Thank you.
Is there an objection to the sheriff's 1 expert? Ms. Kaiser or Mr. Keith?
May we object to Sheriff Lori Smith and be heard on that issue?
Yes.
So at this point, if my notes are correct, the commission has approved receiving testimony in the form of declarations from Chief Lansdowne, Mr. Ganako, Mr. Henderson, Vicki Hennessy.
Mr. Wagner, can we limit? We're past the recipient witnesses. We're talking about the expert witnesses right now. And what we've agreed is that the mayor may call one of the 3 witnesses, Ganako, Lansdowne, or Smith.
Shouldn't Henderson be included in that group?
Henderson is a percipient witness to whom we have invited a declaration.
I'm not sure what percipient facts that Mr. Henderson, I don't think that's been stated this evening, what percipient facts he would testify to. And in fact, Commissioner, with all due respect, you opposed including a declaration from Mr. Henderson.
I did, and I was, the commission, as a group, decided that we would get a declaration from him, and that the time for objecting to that has passed. I mean, we went through that, and we haven't made an ultimate determination as to whether Mr. Henderson's testimony will come in, but we will get a declaration from him. Do you have an objection to the sheriff's experts and this procedure of choosing 1, 2, or 3?
Yes, we object to any of them. to choosing even one. They're not relevant. As Commissioner Rennie mentioned earlier, when asked what the opinion would be, the city attorney was not able to say what that would be. So on that basis and on the basis of relevance, we would continue to maintain an objection to any of those witnesses.
So you have an expert on the standard of care. You have Michael Hennessy, right? So you don't think you need him either?
Respectfully, Commissioner, we're prepared to tell you right now what exactly Mr. Hennessy's, Sheriff Hennessy's opinion would be on the underlying issues.
Okay,
as opposed to.
It sounds like it would relate to the standard of care and whether what conduct falls below the standard of care. I would presume, in light of.
It would relate to the San Francisco Sheriff's Department, specifically the exact department at issue in this case.
Okay, so my point is that it sounds like everyone is in agreement that we need a standard of care expert. Both parties have proposed them. I think certainly if you have one, I think the mayor is entitled to have one. Whether there are specific objections to the opinions that are offered, I think we can deal with that once we know what the opinions are. But I, for one, think that we will need a subject matter standard of care expert, and the mayor and you should be entitled to have one. Does the mayor have any objection to Mr. Hennessy, particularly in light of what we've just discussed?
No, not at all. I mean, we would just ask that all experts' opinions be disclosed by declaration the same way as other witnesses, so that we can all fully prepare for each other's cases. And I just would like to clarify, since I feel as though I'm being misquoted, it is not that I have no idea what these experts will say. It's that I am not coming with a list of opinions to disclose. Obviously, I have plenty of idea what they will say based on my preliminary conversations. It's just that on this short timeline, we're not able yet to do this sort of expert disclosure that you would normally see at the end of civil litigation.
Commissioner Studley.
Mr. Wagner asked specifically to speak to Chief Smith, and do I have that title right? And while the chair has just, Sheriff Smith, while the chair has just indicated the view which I share about each side having a standard of care expert, I'd like to know now whether you have specific objections to Sheriff Smith, because that may go to whether she should be one of the three. Let's hear those now. If you have a specific objection to her as opposed to a general one as to a standard of care expert. I say that because I don't want the mayor to choose among three and then learn later that you had specific reasons that she would not be appropriate that might not apply to the other two.
Thank you, Commissioner. So just to review and make sure I have these clear, we're talking about Michael Ganacco, Chief Lansdowne, and Sheriff Smith. And the question is, do we have specific objections to Smith?
Right, since that was your request when you stood. When you stood up.
I stood up to make an objection to Sheriff Smith, a general objection. As to specifically, there's nothing, and nothing the city attorney has said goes to what exactly, which charge specifically, and again, I make that point, which I hope that we'll come back to, since there are no specific counts in the charges. There's paragraph after paragraph, but there's no specific charges. So that's a very specific objection as to Sheriff Smith. It's not been at all, we don't know at all what specifically Sheriff Smith, what her testimony would cover. And
wouldn't
how
that apply equally to Ganacco and Lansdowne?
Yes, it would.
Okay. My question is, I think we've heard you on that point. Do you have any specific objections to Sheriff Smith as distinct from your broad objection to an expert on the standard of care?
No, Commissioner, thank you.
Thank you.
The next item that we need to address is timing. It appears that we do have rooms available for testimony on June 19th. It's from 6 p.m. on, and June 29th from 8 a.m. to 6 p.m. Mr. St. Croix, I don't know if we have any additional information about other available dates.
Friday, July 20th.
And Friday, July 20th.
From 12:30 to 6:30.
From 12:30 to 6:30.
I'm sorry.
Go ahead.
Were you going to go over the sheriff's witness list?
No.
Okay.
Just because the sheriff said that he didn't need, there were only 2 witnesses that he would want, and his witness list was
Sorry.
defensive. Can the parties, Mr. Kopp, Ms. Kaiser, Mr. Keith, are those dates, are you available?
He seems troubled. I have the same question as Mr. St. Croix. Go ahead.
Okay,
I can't tell if Mr. Kopp is.
Mr. Kopp, am I correct
by
that we don't need to go through your witness list because your witness list was defensive and we've addressed all the witnesses that you think need to be called?
Yes, I don't think we need to go through our witness list at this time. Thank you.
Thank you.
Thank you.
Commissioners, I just want to clarify because this affects how we prepare for the hearing. I mean, I want to.
Microphone.
I'm sorry. I just want to clarify because this affects how we prepare for the hearing, whether the sheriff is essentially dropping all of their fact witnesses. Because, I mean, whatever they're going to do, we just want to have a clear understanding of it. And I don't understand it right now.
They have said that they are going to perhaps get a declaration from Mr. Hennessy, who is also listed as their expert. I presume you will offer a declaration of the sheriff. And you also had Ms. Lopez on your list.
Yes, we do. And we hope to offer her testimony live or remotely. We certainly intend to submit a declaration from her.
Okay. Ms. Haynes?
We hope to be able. I can't tell you right now that we can submit a declaration, but we hope to at least be able to submit a declaration and ideally have her testify live if you wanted to hear from her.
Okay, does that answer your question? Is there anybody else, Mr. Cobb, who you intend to offer affirmative evidence from?
Well, I think that we're not going to foreclose the idea of submitting declarations from the other witnesses on our list, but as you just stated, we are in a defensive posture here. It's going to depend on what the declarations from the mayor say.
Okay, well, you're not going to offer testimony. My understanding was you're not offering testimony or going to seek a declaration from anyone whom we've excluded, because we only went over the mayor's list. Many of those people were redundant to people on your list. The decisions we made about people who are excluded are going to apply equally to your list and to their list.
Then I think we should go over them, because I did not understand that to be the commission's decision. So.
Okay. Do you intend to call Art Agnos?
Respectfully, Commissioners, I would request just a few-minute recess before we go into our witness list.
Okay, we will take 5 minutes.
Thank you.
SF TV. San Francisco Government Television.
Okay, we are back in session. If people could please take their seats. Mr. Wagner, you were going to address the sheriff's witnesses. I will say that I'm a little surprised because when Mr. Kopp stood up, I recall him pretty clearly saying that he only needed 2 witnesses, the mayor and the sheriff, and that the other witnesses were there simply as a defensive measure. So that is sort of the color with which I'm viewing any further discussion about the witnesses on the defendants.
If I may, Commissioner, let me clarify that. I think actually you misunderstood Mr. Kopp. We believe that the distinction is between live witness testimony and declarations, and that's what Mr. Kopp's comments were referring to, that we believe it's our position that in terms of live witness testimony, the only two essential witnesses are the sheriff and the mayor. All other witness testimony could be submitted via declaration. That's what Mr. Kopp intended to convey.
Okay. Please proceed.
As to Mr. Former Mayor Art Agnos?
Yes. Why do we need to hear from former Mayor Agnos?
So, Mayor Agnos is expected to testify such that his testimony would be relevant because it will impeach Mayor Lee's, and it will also demonstrate the mayor's bias. Specifically, he will testify to specific conversations he had with Mayor Lee immediately prior to the mayor's suspension of the sheriff.
And this will relate to what? Why the mayor suspended the sheriff?
Again, Mayor Agnos' testimony is expected to impeach the mayor's credibility.
Meaning that there was another reason why he suspended the sheriff besides the stated charges?
Yes.
Okay. Commissioners' views on testimony from Mr. Agnos? Ms. Kaiser or Mr. Keith, would you like to?
My understanding of the thrust of Mayor Agnos' testimony is that he told Mayor Lee not to suspend Sheriff Mirkarimi, and the mayor decided otherwise. And I don't see how that testimony is relevant to the issue of official misconduct. And I should add, one of the arguments that's been raised in much of the briefing from the sheriff is that this is essentially a political prosecution. And one of the reasons that we have identified so many expert witnesses to talk about practice issues and professional standards issues is to defeat that kind of claim, to show that on the merits the conduct didn't meet that standard. And what I'm gathering from the relevance of that was just described of the Art Agnos testimony is that that's a line that the sheriff is going to pursue. And so we don't think that that's ever been an appropriate sort of set of arguments. He either committed official misconduct or he didn't. The mayor is not on trial for his decision to suspend the sheriff.
Comments from the commissioners or questions for either party?
Well, Mr. Wagner, is that correct? How Mr. Keith characterized what former Mayor Agnos would testify to?
I believe I've already stated what former Mayor Agnos would testify to, and that his testimony would impeach the credibility of Mayor Lee vis-a-vis the testimony regarding the conversations that he had with Mayor Lee.
What would he say? What is this other reason?
Mayor Agnos told the Mayor Lee to talk to Eliana Lopez directly. Mayor Lee declined to do so. Mayor Agnos also asked if Mayor Lee had spoken to any other mayor about his intention to suspend the sheriff, and Mayor Lee indicated that he had not. At a minimum, that is extremely relevant to the mayor's suspension of the sheriff in terms of his motivations, his lack of reviewing any evidence or even contacting Eliana Lopez in this case before he suspended the sheriff. Also, I would add, respectfully, Commissioners, as a former mayor, We could have also called Mayor Agnos, just as the city attorney has called a number of sheriffs, retired sheriffs, or other individuals. We could have called Mayor Agnos as an expert witness on what constitutes official misconduct and when a mayor should suspend another elected official. So I would just add that as well.
Mr. Wagner, assuming that the mayor testifies consistent with what you say, Mayor Agnos is going to testify. There's no need for the Mayor Agnos to come in and say anything, because it doesn't go to attack credibility. It just says the same thing. Isn't that right?
Says the same thing as what?
As what, if he agrees, if you ask him, didn't you tell Mayor Agnos when he came in, didn't you tell him that you hadn't consulted with anybody? Didn't you? He says yes. Nothing that Mayor Agnos is saying goes to impeach credibility.
Well, without having heard the mayor's case in chief, sure, I can state at the outset that every witness that the sheriff would call would be to rebut the mayor's case in chief, but I think that goes without saying. I think the question here is, what is the relevance of former Mayor Art Agnos' testimony? And I'm presuming that Mayor Lee is not going to take the stand before you and say that he refused to or declined to talk to any other mayor about the suspension.
But you could ask him on cross-examination, is I think Mr. Rennie's point.
Yes, that is correct.
Commissioner Shelby?
I don't see that the mayor's motivation or state of mind has any part in what we're about here. We have, indeed, it's for the very reason that the people passed this initiative to give us the job of determining whether official misconduct took place. And we can say yes or no, but the motivation behind it, this line puzzles me. So maybe some of you see something else.
To me, I mean, I am less. I see your point, although I'm additionally persuaded that we don't need Mayor Agnos, because I haven't heard any reason, anything that he's going to say that about a different reason for why the suspension happened, which is what I thought you said he was going to say in response to my earlier question.
Respectfully, Commissioners, the city attorney attacked the sheriff for saying or suggesting that all of this was political. It's not the city attorney's role to determine what the defense of the sheriff is, or what an appropriate defense, or which witnesses the sheriff should be able to call. That's not the city attorney's call. And respectfully, the sheriff is entitled to put on as vigorous defense as he can against the charges. Mayor Agnos is a former mayor of San Francisco. He surely knows a little bit about what the responsibilities of a mayor with regard to a suspension of public officials, and he spoke directly to Mayor Lee immediately before Mayor Lee suspended the sheriff on this exact issue. So if the city attorney can have witnesses come in who have nothing to offer except some roundabout opinion on what the responsibility of a sheriff in some other part of California is, and they have no percipient knowledge at all, or for example, Mr. Henderson has no knowledge at all as to any of the underlying facts of this case, and then and he can come in, but we are suggesting that Mr. Agnos be permitted to testify by declaration, and but somehow, even though he spoke to the mayor, that's not relevant. I respectfully disagree.
Thank you. Commissioners, does anybody here think that we should receive a declaration from Mayor Agnos? No?
No, not for the purpose, not from what we've heard tonight. I don't think it's useful.
Phil Bronstein. Why do we need to hear from Phil Bronstein?
Between January 1st and January 4th, Phil Bronstein spoke with Ivory Madison regarding the underlying facts of this case. Phil Bronstein's testimony is relevant to Ivory Madison's credibility and relevant to what Ivory Madison actually said to Mr. Bronstein regarding the underlying facts of the case.
So she told something different to Mr. Bronstein than, I guess it's hard to compare what, but are you expecting to elicit testimony from him that she said something different than what you expect her to testify about?
Yes.
What differences are you intending to elicit?
I have not had a chance. We have not been able to talk to Mr. Bronstein directly. So as to what...
So then how do you know that it's going to be inconsistent?
Because Mr. Bronstein has told others that the only thing that he talked to Ivory Madison about was whether Madison could get phone numbers of 3 individuals, and we believe that the testimony between the two will conflict. Moreover, Mr. Bronstein also is a former editor of the San Francisco Chronicle, and again goes to the political nature of this case, which is certainly, we absolutely believe that on a factual basis alone, the facts stand for themselves. But to ignore the politics of this case, to ignore the political reality, to ignore the fact that Agnos or Bronstein were key players in this case, and to not allow their testimony would be a great injustice. And if I may go back to former Mayor Art Agnos, if you're not going to allow us to provide a declaration outright, I would respectfully request that you at least permit us to call him as a rebuttal witness in the event that, based on Mayor Lee's testimony.
I think we can reserve that decision, but I wouldn't preclude that.
Thank you.
Mr. Bronstein, do the commissioners have views on Mr. Bronstein? I am sensitive and cognizant that the sheriff is trying to put on a defense here, and I don't want to hamper the defense of the case. But I am really having a hard time, in light of what I've heard, seeing how Phil Bronstein is going to have anything that's probative to what we're trying to decide. I mean, you guys were up here saying that this should not be about politics, which I agree with, and so I'm having a hard time seeing the relevance.
Well, I want to make clear that regardless of what we say about Mayor Agnos or Mr. Bronstein, if when the live testimony of the mayor or anyone else you think would be rebutted by somebody who's on your witness list or who isn't on your witness list, I think I, for one, would say certainly you've got a right to call them if it goes to rebut it. I think the question that we're asking now is, in your affirmative case, in the case that you're making affirmatively, not attacking the mayor's case, but the affirmative case as to why we should not recommend to the Board of Supervisors that it go the way the mayor's decided. Those are the witnesses I want to know about tonight as to whether or not they're going to be called. You clearly can have the right to call somebody in rebuttal if you elicit testimony that is inconsistent with what you know they're going to say.
And that is probative to the charges. Is there any, do any of the commissioners think that we should take a declaration from Phil Bronstein?
Not what I've heard.
Yeah, not
based on what we've heard. Lenny De Leon.
Lenny De Leon has worked with Eliana Lopez and Eliana Lopez, the son of Eliana Lopez and Sheriff Mirkarimi, for some period of time as a daycare provider for their son. Lenny De Leon had many interactions with Eliana Lopez between January 1st and January 5th, 2012. Lenny De Leon would testify as to Eliana Lopez, her demeanor, her state of mind, so I'll leave it at that.
Commissioners, views? It seems that to me that based on the breadth that we allowed for the mayor with respect to perceptions of key witnesses in and around the time of the incident, that we should at least take a declaration from Ms. De Leon.
I agree.
Any objections? Okay. Ms. Haynes, we don't have to discuss. Mr. Keene was on the mayor's list, and we decided we didn't need to hear from Mr.
What about Jan Dempsey?
Jan Dempsey, we decided we didn't need to hear from because you guys are going to work out a stipulation. Is that still the case?
I would only add that Jan Dempsey's testimony by declaration would be relevant, or is relevant, and would be valuable in your deliberations, because Jan Dempsey, as a retired undersheriff, could testify that Sheriff Mirkarimi, prior to taking the oath of office, was not performing the duties of sheriff, and was, despite what the city attorney has alleged in their briefing.
Okay, well, obviously you're not going to object to them bringing in Dempsey if you guys can't reach a stipulation, and I think they would be hard-pressed to object to you doing the same.
Understood. Thank you.
Having trouble hearing you.
I will try to speak more into the mic. Unfortunately, I've been talking a lot, so that's part of the problem. Ms. Haynes, we've discussed. Mr. Keene, do you have any need for Mr. Keene in light of the discussion we had?
No, thank you.
Mr. Lee, Ms. Lopez, Ms. Madison, Mr. Mertens. I don't think any need to discuss them. Nancy Miller. Why do we need to hear from Nancy Miller?
Nancy Miller is the interim executive officer of the San Francisco Local Agency Formation Commission, or LAFCO. Ms. Miller is expected to testify by declaration as to her knowledge of Sheriff Mirkarimi's presence at a LAFCO event on January 4th, 2012.
But why is that relevant to what we're
because
trying to decide?
The mayor has alleged that on that date, the sheriff was engaged in the witness dissuasion and encouraging others to destroy evidence. Ms. Miller can testify that, in fact, at least for some period of time on the 4th, Sheriff Mirkarimi was present at that event.
Is she going to be able to identify specific times?
Yes.
Commissioners, views on Ms. Miller?
In anticipation of that offer, I can't see how that would cover the whole time frame, but I think your earlier point about letting the defense put on the defense that they want, I wouldn't object to receiving that for whatever weight it might have.
I agree.
Okay.
Yeah.
Mr. Mirkarimi, I think we can skip. Ms. Nieves?
Try this.
Commissioners, we would only call Ms. Nieves as possibly as a rebuttal witness to if Flores or Ms. Lemon is permitted to testify.
Okay, so I see your point with Flores. Lemon is an expert. Why does Nieves rebut Lemon?
Well, my understanding from the city attorney's comments earlier is that Ms. Lemon would testify that there must have been some other conduct at issue or some other instances of that would qualify as official misconduct regarding how the sheriff has interacted or interacts with other people in his life. Evelyn Nieves lived with the sheriff for several years and could provide testimony to the contrary.
Okay. Ms. Kaiser, you want to be heard on this?
Ms. Lemon is not going to be providing testimony about other acts of misconduct. She's going to be providing testimony about the nature of domestic violence and specifically the facts that are elicited in this case and how they do or do not relate to what is known about domestic violence. We do think that Ms. Nieves should not be a rebuttal witness to an expert. Rather, the expert should testify on the basis of all of the facts that are elicited. And for that reason, we would have no objection to Ms. Nieves putting in a declaration, and that should be part of what Ms. Lemon opines about, is why would you see it here and not there, for example.
If I may, Commissioners, consistent with Commissioner Rennie's point earlier, which thank you for the clarification, and makes perfect sense in terms of rebuttal witnesses, we would withdraw Evelyn Nieves as a witness for a case in chief and just reserve the right to call her as a rebuttal witness if that becomes necessary.
Okay, thank you. Lydia Stiglich.
The same applies to Lydia Stiglich. Unless we would only call Ms. Stiglich as a rebuttal witness, possibly.
So Ms. Stiglich would waive the privilege to testify?
I can't, obviously, I can't comment on whether Ms. Stiglich would waive a privilege at this point right now.
Okay, well, you're withdrawing her as a affirmative witness, right? Eamon Tekin.
Similar to Lenny De Leon and Nancy Miller, Eamon Tekin would be a witness who would testify as to Eliana Lopez's demeanor, state of mind, et cetera, on December 31st, 2011. Mr. Tekin works at a restaurant that Ms. Lopez went to on the evening of December 31st and could provide testimony as to Eliana Lopez on that date.
Views of the commissioners on Mr. Tekin.
I think we should allow it for the same reasons that we're allowing Lenny De Leon.
I agree with that. Any dissenting views? Callie Williams. Now, when we talked about Callie Williams, there was an objection to Callie Williams providing any testimony. So has that view now changed?
In light of the conversations and everything else this evening, no, that's not changed.
Okay. So you do not intend to call Callie Williams as an affirmative witness?
No.
Of course, if she ends up here, you can cross-examine her, or if she submits a declaration, you can do that. Andrea Wright.
Andrea Wright is Sheriff Mirkarimi's probation officer, and we would only call her as a rebuttal witness.
Okay. Thank you, Mr. Wagner. So just to recap, Art Agnos, the commission decided we would not need a declaration. Same with Phil Bronstein. Jan Dempsey, we expect the parties to reach a stipulation on. John Keane was withdrawn. Evelyn Nieves was withdrawn. Lydia Stiglich was withdrawn. Callie Williams was withdrawn. And Angia Wright was withdrawn. Of course, these witnesses are subject to potentially being called as rebuttal witnesses if their testimony would rebut and would be probative. Did I say that?
Mr. Chair, I think you may have said this, but Nancy Miller is a yes?
I just said the no's.
Oh, okay.
So everyone
Sorry.
else is
Okay.
in.
That's why I didn't hear her, thanks.
Did I get that correctly, Mr. Wagner?
You did, as to the noes.
Okay, thank you. And everybody else is a yes. Okay. Anything else with respect to your witnesses? Mr. Wagner?
No, thank you.
I would like to next address scheduling. I think, like all the commissioners have said at the outset, we want this to proceed as quickly as we reasonably can proceed. We're volunteers, but we're trying to open up our schedule so that it works and we can get this done in an efficient and fair manner. So we do have a room and availability on the 19th of June to begin the evidentiary proceeding. Is counsel available on that date in the evening? I think we initially had a limitation on start time, but I wanted to double check with the commissioners. What time are the commissioners available on that day?
I believe I had initially indicated that I wasn't available till 6, and I could be available at our usual starting time of 5:30 or even 5, if that's helpful.
Let's see. Okay. Are the other commissioners available starting at 5?
Yes.
Okay. Let's hear from the parties.
Respectfully, Commissioners, at the outset, June 19th is a full month away from this evening. As Commissioner Herr mentioned earlier, the Charter anticipates these proceedings beginning within 5 days of the filing of the charges of official misconduct.
I didn't say that, and that's not what it says. That it could start as soon as 5 days after.
As soon,
No less
thank
than
you for the
5
correction.
days.
In any event, 5 days, no sooner than 5 days, and then there's no end date. But as Commissioner Herr mentioned earlier, and I thought the import of your comments were that these proceedings and this process should be carried out with the greatest expediency because for a number of other reasons, among other reasons, the mayor suspended the sheriff without pay. This is all dragging, this whole process requires tremendous amount of time and effort. We would respectfully request this matter being heard much sooner than the 19th. And I understand the director's identification of a time that a hearing room is available, but we'd be willing to go to any room in City Hall to have this matter heard, and rather than having it heard one hearing on the 19th, another one 10 days later on the 29th, and then the next date is July 20th, these hearings we could easily take up 3 to 5 or more separate hearings. I would respectfully request on the benefit, for the benefit of all parties, that rather than having a date here and a date a month later and another date a month after that, taking this all possibly through the rest of the year, that we pick 1 week, everybody get out their calendars and pick 1 week and identify 3 to 5 days back to back where this whole matter can be heard and dispensed with in an expedient time frame.
Mr. Wagner, two points in response. One is that unfortunately we cannot hold this meeting anywhere in City Hall. We're required to hold it in a room where we're equipped for TV. So that's not within our control. So there are only so many rooms that have that capability. So we are limited by that. As far as your request for consecutive dates, I would love to have consecutive dates. We just cannot, I don't think there's availability where we're all available on consecutive dates that's going to be sooner than June 19th. If there is, I would certainly welcome that possibility. How early can you start? Or would you like to start?
He doesn't start.
We can start immediately, meaning this week, and next week, or the week after. But certainly, there's no need for us to wait a full month, 2-3 months later.
3 weeks. 3 weeks. 3 weeks from today, the 19th.
We're already, from the sheriff's point of view, he was suspended already months ago. This case has been going on since January. You know, at what point is enough enough? You know, I know that there's no statutory or deadline in the charter that says these proceedings have to be wrapped up by a certain date.
Mr. Wagner, you've answered my question. Thank you. Okay. I do not think that we could I think that the 19th is unfortunately the earliest we're going to be able to do this. And we've, you know, Commissioner St. Croix has looked at schedules of the commissioners too. You know, we have full-time jobs, and so we're just not going to be able to do that. And in addition, we need to see these declarations. I mean, your side has made objections and has agreed that to the extent these declarations don't have relevant evidence, you want us to exclude them, and I think you're right that we should be able to examine that. But that has to happen before we actually take testimony. So 3 weeks, I mean, frankly, 3 weeks is very soon after now if you're contemplating a proceeding where you're taking evidence and evaluating declarations. So I appreciate your objection, and you know, you should make your record.
And if it were the 19th, 20th, and 21st, that would be great. And I apologize, I did get it wrong, and thank you for the correction, Commissioner Studley. It is 3 weeks out and not a month. I just, if there's any way possible to have these hearings as quickly as possible, given the concerns that you've raised, that is our strong preference, and we'll clear our calendars to make that happen.
And the witnesses. In other words, you can commit to your witnesses being available on whatever dates we pick.
We would do our utmost to make that happen, Commissioner. Thank you.
Okay. Let's hear.
I wonder if this is something that we can do tonight, or whether it hinges on the staff determining whether there are any hearing rooms available.
So I understand that in a
sooner
pinch,
than the July dates.
In a pinch, that we could get potentially get room 263 on some dates. And we can set tentative schedules now and hope to work out the room. But I am concerned about waiting to set dates. I think we need to do that. So I'd like to hear from the mayor.
So we're available on all three of the dates selected by the commission. Our concern is that we be able to submit the declarations, get the request for cross-examination and any objections to admissibility, so that we can then get our witnesses together and get them to the hearings, those that need to appear. I mean, our witnesses have a whole patchwork of availability. I mean, there's certainly on any given date, I'm sure we could find 3 or 4 who can come. Mm-hmm. My concern is that we just have a process where each side submits the declarations of the witnesses to support their side, and the other side gets to request cross-examination. And then there's rulings from the board on which witnesses' declarations are going to be accepted, which ones not, and then we can get the witnesses in. So I just want to make sure that the scheduling is part of a larger process of exchanging declarations, cross-examination, and frankly also making subpoena requests to the commission so that we can get independent witnesses into the hearing.
Okay.
Mr. Chairman.
Yes.
A scenario that may be palatable to moving this along is we have that first or the next installment of this hearing, as you stated, on the 19th that evening at 5 o'clock till however late we go. There's an Ethics Commission monthly meeting the following Monday. We could devote.
I am not here on the 25th.
Okay.
I
Never
chair,
mind.
and I would clear the deck for almost anything else, but I chair a federal commission that meets
Okay.
on the 25th and 26th in
So
Washington.
we have the other hearing on the 29th, which is 10 days after the 19th. I will try to isolate a couple of nights between those two, if it's humanly possible, or right after those two.
Okay. Are there dates where the parties or the commissioners between the 19th and the 29th where there's evening unavailability? Or maybe I should say it the other way. Are there days on which there is evening availability between the 19th and the 29th of June?
Okay, this is June 19th and 29th?
Yes. So Commissioner Studley's identified the 25th and 26th.
I hate to do this.
It's unavailable.
And I expect to be away the 27th. I could do the 28th. And we're scheduled to meet on the 29th.
Okay, so the 28th.
What about
And I could meet on the 20th and 21st.
20th and 21st?
20th and 21st. Any problems with the 20th or 21st?
Fine.
I can make myself available.
Okay. So 20th, 21st, and 28th in the evening. Any objection to the?
And we're scheduled to meet all day on the 29th.
We have all day on the 29th available as of now. Any objection from the parties to any of the dates we have discussed?
I just think that with the need to send out subpoenas and make rulings on the declarations and tell witnesses to get here, we'll need to know. We'll probably only find out those things on the 19th, so it might be very hard to get a witness in on the 20th or the 21st if we're only finding out about this if we're only getting a ruling on the 19th. I mean, we don't have a problem with having these hearings close together, but the problem might be having so many days in a row immediately.
Mr. Wagner.
As to any rulings that may need to happen on admissibility or testimony, we're certainly fine with how we've proceeded up until now, which is having the chair make the decisions on those matters.
Yeah, even the admissibility of evidence?
Yes, thank you.
Why don't I solicit the mayor's view on that?
I think on a lot of these evidentiary questions, there may be differences of opinion within the commission, and so I think we probably need to have the decisions made at a hearing. I mean, of course, there are always issues that are somewhat easy, but it's really hard to sort out the easy ones from the difficult ones.
Okay. I think if there's a dispute among the parties, I don't even think it's worth bringing it up with the commission, because I think we would need a stipulation on that sort of delegation. Okay, well, here's what I propose. I propose that we have Mr. St. Croix look at those dates to see if we can get hearing rooms. I would expect both parties to do their utmost to make sure we have witnesses, and I know for the mayor that is somewhat of a bigger burden because you go first. But there are witnesses to whom we have said we expect live testimony. I think there are a number of witnesses who we expect declarations, and that we don't expect to exclude declarations from many people. So perhaps plan accordingly and be prepared to have those witnesses testify earlier on. Okay, so now let's work back from the 19th as to deadlines for submissions. Are the parties prepared to submit declarations on June 5th? June 5th, 1 week from today.
So on fact witnesses, I think we'll need 2 weeks to get all the fact witness declarations in. And then another issue is that there hasn't been any discovery in the. Sorry about that. Another issue is that there hasn't been any discovery in the case. The sheriff still has documents that we don't have, things like telephone records that he obtained in the criminal action. We're doing our utmost through the courts to get those. We're doing our very best to get them as quickly as we can, but we are at a disadvantage compared to the sheriff with regard to crucial information like that can resolve some of these credibility disputes. And so I understand the commission's desire to move very quickly, but I think that we really need 2 weeks to get the fact witness declarations in and to get some of these things that we have been unable to get from the sheriff.
What about, so experts you think you can get earlier?
No, I think we would normally expect to do our expert declarations based on the facts that have come out through discovery. We don't want our experts to be offering opinions when the facts aren't in. So we could do the experts very shortly after that.
Okay. Do you have a view, Mr. Kopp?
For our part, we'd be prepared to submit fact witness declarations in 1 week on June 5th. Actually, we'd probably submit all of our declarations on June 5th.
Okay. Mr. Keith, I mean, many of these people whom you're submitting a declaration from are city employees.
Yes.
And I know this, your investigation has, obviously you did some investigation beforehand and perhaps it's continuing. From whom could you get a declaration by June 5th?
It's not a matter of who, it's more a matter of how many, and just trying to get in touch with people in this very short time frame. I do have a couple of witnesses who aren't available this week, who aren't available within that time frame or that entire time frame. So really, I think we could get a lot of them, but we couldn't get all of them. It's not, again, not a matter of who, it's really a matter of how many and schedules.
What about June 8th? Would that be doable? It's kind of a compromise.
Yes.
Okay, so let's
for fact witnesses.
Let's have fact witness declarations by June 8th. Any objections to fact witnesses can we get by the 13th? Is that doable?
And can we also have the request for cross-examination be due?
Yes.
At that time?
Okay. On the 19th, we will convene and discuss admissibility. I think the mayor should be prepared to call witnesses. I'm not sure we'll get to it, but I think you should be prepared to call a witness on the 19th.
How many?
Why don't you have two ready?
Okay.
And if we get beyond that, we'll understand and we'll recess.
We'll do our best.
Okay, thank you. With respect to experts, when do the parties propose having having an expert declaration ready to go?
Well, we have fewer experts, so we can propose to get a declaration certainly before the 19th, possibly as soon as the 13th.
Would the 15th work? Wait, you're going to get, hold on, you're going to get the witness. Yeah, how about the 15th?
I think that'll work.
Okay.
Yeah.
Okay. So to recap, just so we're all clear, June 8th will be the deadline for submitting any fact witness declarations on which a party intends to rely. June 13th will be the date for objections to fact witness declarations, and those objections should identify specific paragraphs to which the party is objecting. That is also going to be the date for identifying which witnesses the party would like to cross-examine. June 15th is going to be the date when we receive expert declarations. Can we receive objections on the 18th? That really does not give us much time to review that.
I wonder if with the experts, perhaps the commission can just reserve the rulings for later, because I know there may be a lot of questions about relevance that goes to a lot of the legal issues. So it might make sense to reserve ruling on the experts.
We could reserve ruling, but we'd want to get the objections. Is the 18th doable?
Well, I anticipate that we're going to have the majority of the objections, so I'd like more time than the weekend of the 16th and 17th. As a matter of fact, if there'd be a way for the commission to hold off on admissibility of expert witness testimony until sometime after the 19th, that might be the best way to go. Perhaps we could.
How about you guys make objections to evidence by the 20th, and then we'll rule on it sometime thereafter, whenever we can meet, but hopefully before the 29th. Is that acceptable?
Yes.
Okay, same request that objections to experts be paragraph specific. I'm going to assume that experts are going to be cross-examined, but if either party feels the need to have a separate disclosure of your intent to cross-examine an expert, let me know. Do you want to have that separate?
Yes.
Okay.
I mean, they may not want cross of all. So.
Okay. So on the 20th, please also identify whether you intend to cross-examine the opposing party's expert. Okay. Are there? Mr. Keith had mentioned discovery. Today is the 30th of May. What discovery, other than these witness statements, do the parties believe they need to proceed to begin the hearing, the taking of evidence on June 19th?
We don't think we need anything. We think that this case should have been prepared for presentation prior to the filing of the written charges of official misconduct. I actually went and did some historical research today to find out that in the Mazzola case, the trial commenced 14 days after the filing of the written charges of official misconduct, and that's because the case was prepared prior to Mayor Moscone bringing those charges. That's what should have been done here. It apparently wasn't done, but I don't think that the commission needs to countenance that lack of preparation by foisting discovery on us. We've already got a significant burden in front of us to prepare for the 19th. We don't need to complicate that by having discovery, in our opinion.
Mr. Keith?
Well, I think this goes back to an issue that we raised at the last hearing, which pertains to the duty of an elected official to cooperate with an investigation. In the normal investigation, these materials would have been provided to us. They would have been given to us by the employee, and if the employee didn't want to cooperate, they would resign. So that's typically how these things go. This one has not gone that way. So we've been going to the courts, and from our standpoint, what we need most significantly are the telephone records that the sheriff obtained during discovery in the criminal action. We've got a court action on file for that, but our hearing isn't until June 5th, so we're on a very tight timeline. So what I would like to do is get discovery of those telephone records.
Okay, hold on. Before Mr. Kopp, you speak. So that's the telephone records is what you want. Otherwise, you are prepared to go to the evidentiary hearing based on the witness statements.
The telephone records, and then whatever was, quote unquote, I guess they use the term discovered in the criminal action. It's just a bunch of information that the DA hands to the criminal defendant. It should be a packet of information that they have. They shouldn't have to search their records. It's there. We'd like to get that because that's going to contain notes of interviews with various witnesses. It's impeachment material that they have that we don't have.
So you're talking about the materials the prosecutor turned over to the sheriff during the criminal action?
Yes.
Okay, and this is going to be heard by the Superior Court on the 5th?
Oh,
both issues?
No, only the telephone records will be heard by the Superior Court.
Have you requested the Brady materials?
I'm sorry. We have also moved for enforcement of a subpoena for the materials obtained in discovery. It had slipped my mind, and that is set for the 5th.
That's set for the 5th as well?
Yes.
Okay. Mr. Kopp, sorry I interrupted you when you were about to speak.
We have made an offer to disclose some phone records to the mayor in order to, these all go to this allegation of witness dissuasion. We've offered to disclose more than just phone records in an effort to narrow the focus of this inquiry. I have not had a response on that yet. But no, we don't agree that just because charges of official misconduct are filed, that means the sheriff has to hand over every phone call he's ever made within a 2-week period. And we're also not aware of anything that would require the defendant in a criminal action to then disclose the discovery he received to the mayor in this type of a proceeding. And I note that the mayor has not gone and served subpoenas on the DA for this material. So, I don't think that the sheriff is under any duty to turn this information over. And as I said before, I think they should have been ready to prove the charges up when the charges were filed. So I don't think there needs to be any additional discovery.
My view on this is that if the Superior Court is going to adjudicate this issue on June 5th, the parties can make the court aware of our proceedings. I would, in sort of I think it's prudent that we, the commission, not make a ruling on a subpoena that was not issued by the commission relating to matters that are about to be adjudicated by the state court. I welcome the views of my fellow commissioners and the parties to that view.
I concur.
There can be discovery in this proceeding going on alongside whatever proceedings are happening in the Superior Court. So I don't think that there's a barrier to the commission essentially saying we're going to have discovery rules. Each side submit a discovery request. And I would also note sometimes the Superior Court orders that the court may issue an order on June 5th. It may continue the matter. It may order the parties to meet and confer further. There may be an appeal from the other side, which would effectively deprive us of ever having the evidence at all, given the timetable that we're looking at. So, these are my concerns with just going along the Superior Court track. Even if we sort of, quote unquote, win the motion, an appeal essentially deprives us of the evidence. Or even a 10 days to comply with the order deprives us of the evidence.
I welcome the views of the commissioners.
I agree that since the Superior Court is already handling this matter, I don't think we should rule on it.
Any dissenting views to that? I agree. I think we should let the Superior Court action play its course, and as far as the mayor's decision to use the mayor's subpoena power to get documents, it's not clear to me that we, the commission, have the power to enforce that subpoena in any event. So that's where we are on that issue. There were a number of legal issues that the parties briefed, and I, for one, very much appreciate the briefing of those issues. I think deferring, though, a final decision and perhaps even further discussion on issues like whether the plea is sufficient in and of itself or other legal issues that we asked you to brief, that we should defer those until after we hear the evidence. Are the parties, is the commission in agreement with that?
Yes.
Yes.
Okay. Anything that we have not addressed that the parties think that we need to address tonight?
One matter would be the date by which we should inform the commission that we would like the commission to issue subpoenas for witness testimony.
I suppose you can make that request. I certainly wouldn't limit your ability to make such a request after the court rules on the issue. I will say that I am.
I'm sorry. I think I may have misspoken of that, or I may have misunderstood something. I meant for the commission to issue subpoenas to witnesses that it wishes to
Oh, I'm
testify
sorry.
at
Okay.
the hearing.
Yeah. Okay, so you are going to identify the witnesses and then object by the 13th. So I welcome views from the commissioners. My concern is that we likely would want to issue a subpoena 10 days in advance, which means we would be issuing subpoenas for witnesses whom we may not need. At least one thing that I've done in the past in civil matters is you issue the subpoena. The subpoena is for on-call. The attorney, the parties and the commission agree that witnesses will just be on 24 hours advance notice of when they will appear based on what the available dates are, and that we don't have to subpoena them for a specific date within that time period.
I just know that when the commission issues subpoenas, it does it under its own authority. So I mean, we don't have a problem with being able to come to the commission multiple times to ask for subpoenas, but I just want to make sure that we know what the rule is.
Maybe I should defer. Well, let me solicit views from the commissioners. If there are any thoughts on that.
Well, I thought your 10 days suggestion, it may be a little difficult to do it because they may not identify who the witnesses they need to get subpoenas. Can we have an agreement from, at least from the city, that to the extent that a witness who's coming live is a city employee, that there isn't a need to get a subpoena for them?
Yes. I mean, we'll do our very best with scheduling, but no subpoena will be necessary.
Okay, so we're only talking about the witnesses that either party doesn't have control over.
Yes.
Essentially. This is a question from Mr. St. Croix or Mr. Embledge. Are our subpoenas effective if issued within 10 days? In other words, typically, at least in my experience, typically a subpoena has a reasonable time requirement, and that's often interpreted to be 10 days. So if a witness did not appear, we might have an issue if we issued the subpoena too late.
I don't know that there's any standard that governs us, but we generally leave lead time in when we do them, so we've never had an issue with that. They're usually about 2 weeks in advance.
My understanding is the same as yours, reasonable time.
Mm-hmm.
I'm sorry, it's what?
Same as there's a reasonable time requirement.
Maybe I should ask you this. Mr. Keith, for any of the witnesses whom you intend to call, I mean, do you expect any of them to be hostile in the sense that there's likely to be a challenge to a subpoena based on timeliness?
Well, Ms. Lopez, though, of course, with her being
Microphone.
in Venezuela. Oh, I'm
Microphone.
sorry. Ms. Lopez, but with her being in Venezuela, I don't see us being able to serve her. Ms. Haynes, and I mean the other witnesses, we can telephone them, of course, but I think from our perspective, we would like to be able to subpoena them to ensure that they show up. That would be Madison, Mertens, Williams.
Okay, so I mean, it sounds like from your list, Lopez and Haynes are two that may not. Okay, why don't we do this? Why don't you make requests for subpoenas by the 13th? And are the parties, and I'll ask the commissioners too, are the parties in agreement that the chair can actually, does the chair need to sign a subpoena to issue forth from the commission?
No.
Okay, good. So if the parties would agree to delegate authority to the chair to approve subpoenas being issued, then I think we can get that out very soon thereafter. Is that acceptable?
Yes. Yes.
Okay, so by the 13th, you'll let us know who you want us to subpoena. We will get those out and notice them maybe for the later end if we have to, but okay. Anything else?
No.
Mr. Keith?
Mr. Wagner had made a request essentially for a bill of particulars. That's something, I mean, we're happy to file charges that look more like counts for him to deal with that, to sort of file an amended set of charges with count 1, count 2, count 3. We can do that shortly. To essentially provide them with the notice that they are complaining that they don't have.
Okay. When can you do that by?
By the end of this week.
Is that acceptable, Mr. Kopp?
Yes.
Great, thank you.
I would only add for the record, however, that doesn't cure the defect of not having filed a specific charges at the outset, and we certainly, I just make that for the record. Thank you.
Your objection is noted. Thank you. Mr. Embledge or the commissioners, anything else that we need to address tonight? Okay, then we will take public comment. Public comment will be limited to 2 minutes. I will leave it to the officers to identify where people should stand. Okay, I've been told that everyone needs to line up on that side.
10 at a time, please.
Okay. Officer, I'm going to leave it to you to manage that process. Again, public comment due to the number of people who are commenting will be limited to 2 minutes. I'm going to instruct the commission staff to turn off the microphone.
Get my paper from him.
At the end of 2 minutes. You will get a 30-second warning. That's the first ring. After the second ring, the microphone is going to go off, and we're going to invite the next speaker up. As a preliminary matter, I want to thank everyone here for their patience in waiting for us to get to this point. And we welcome the first speaker. Thank you.
Okay. My name is Paulette Brown.
I'm sorry, Ms. Brown. Let's reset her time. Please proceed.
Hi, my name is Paulette Brown, and I'm a mother who's lost her child to homicide on the streets of San Francisco. And I'm here to I'm here to say, why are we spending our tax dollars on something like this when we have all our children being murdered in the street? And we have, can I use the overhead? Young men that are being murdered in the street of San Francisco, and still no justice, still no money, still nothing. We can use this money to solve our cases. My son's case has been for 6 years. He's still laying up there in the graveyard with a cold case. And I say this because I've been here before concerning the fire chief when she and I'm bringing this up. I have nothing against these people, but Ross was there when my son was murdered. So I support him in that way because he's been there when all of our children have been laying in that street. But you have the fire chief that beat her husband, and nobody done anything about it. Where's the standards? Where's the standards for that? Here you have, I have nothing against this man either, Michael Markhams. He murdered his father. He murdered his father. So, and he still was the assistant sheriff. The assistant sheriff. Where is the standards for that? And not only that, in jail, he wasn't a model prisoner, but he came out of prison, and still became the assistant sheriff. So what do we do about this? This same stuff, we're getting this same stuff with our own children. Where's the standards for this? What do we do? And when murder happens, I have something to say about it. I have nothing against this man, but he murdered his father. That's domestic violence. That's elder abuse.
Thank you, Ms. Brown.
Good evening. My name is Paul Currier. I was on the candidate. I was a candidate for mayor in 2011. I was on the ballot. I came in dead last, but I still was on the ballot, and I stuck it all the way through. And on the night of the election, I asked to see how the votes were counted in San Francisco. As a candidate, I wanted to see. No one can see. It's done in secret. The count of the vote is rigged in this city. Mayor Adley is running an organized crime deal here in San Francisco. I talked about it on the campaign. We have 4 supervisors in Sunshine Case 11048 who have been charged with misdemeanors in the supervisor's chambers on May 24th, 2011, when they fraudulently passed the Park Merced development project. They violated the Brown Act. They violated the Public Records Act. I'm a longtime friend of Chris Cunney, and I'm a longtime friend of Ross Mirkarimi because I used to be a San Francisco Green. I supported Chris Cunney in the election last year, and I support Ross Mirkarimi now. I've changed my position, and I'll tell you why. Because Ross Mirkarimi has a sense of integrity. He may have an ego the size of the Rock of Gibraltar, but he has a sense of integrity, and he doesn't stand for organized crime. And the reason the Sunshine Case 11048, you can Google it, anybody in San Francisco can Google it, I put it on my Tumblr. This is so important. On March 13th, it was referred to you as the Ethics Commissioner and the District Attorney for Enforcement, and you blocked the case. You blocked the case, and a case that was filed 1 week later against the sheriff was put forward. You're out of order and you're violating the civil rights of all the people at Park Merced.
Good evening. My name is Antonio. I got permission to call Sheriff Ross. I am a little bit disappointed the fact that you did not allow Phil Bernstein. Again, an article say that the neighbor, Ivory Madsen, called Phil Bernstein, then executive editor of San Francisco Chronicle. So she called him to report that there is a crime between Ross and his wife, but she didn't call the police right after 4 days. So what was the motivation of that? It's also important to find out who are the people behind the scenes orchestrating this conspiracy. Based on the evidence that I have here, Ross got 38,000 plus votes. Ed Lee got 36,000 plus votes. Dennis Herrera got 12,000 plus votes. For Ross, it's more viable to be a mayor of San Francisco. That's why they want to get rid of him. And this is wrong. Dianne Feinstein, she endorsed Chris Cooney, Kamala Harris, Gavin Newsom. All these people support Chris Cooney, the establishment. They don't want Ross because he has a different political view. So this is all politics. And I feel that this ethics board, you guys are tainting. I think, I'm not assuming that you guys are going to make a decision against Ross, but I'd like to see Board of Supervisors make better decisions. I was a victim of domestic violence, assault with deadly weapon. I have police recording all the documentation, but the system didn't help me. This case, you got to throw it out. Throw out the case.
Thank you, sir.
Please, excuse me, could you pass this to yeah.
Good evening, Commissioners. I'm Patrick Manetshaw. You've seen me before. I've asked you over and over, what happened to my referral to this Ethics Commission over Mr. John St. Croix and Ms. Tanya Letiju in the Controller's Office? Well, I just found out from Mr. Chatfield that my cases have been transferred to the San Jose City Attorney. This body has a member appointed to it by the mayor. Whichever one of you it is that was appointed by the mayor should recuse yourself from the Mirkarimi hearing. And you might consider transferring this case. You might transfer this case to San Jose where it belongs because you are all implicated by not being able to hold a fair hearing. In fact, today, Larry Bush, proprietor of CityReport.com, came out with an article online. It's posted at www.city.report.com, in which he notes that Mr. Mirkarimi's lawyers submitted several exhibits, and the second one shows that Mr. Mirkarimi is being treated and held to a different standard than other city officials, but it ties directly to Mayor Ed Lee. The city attorney, for his part, explains that he took no action on several other cases of official misconduct. That may include the 25 that you have dismissed without any public hearings whatsoever. There is no difference in those other cases and the case with Mr. Mirkarimi, because it seems like the mayor is playing by his own rules and that you are facilitating him playing by his rules and making them up as he goes along.
My name is Barbara Tingari. I was struck by an unknown source who took a survey showing 62% support Mayor Edwin Lee. I questioned the integrity of the unknown source and the integrity on the outcome of the survey. For example, who were members of the sampling and who conducted the survey? We need a name and we need to know who took part in the survey. For example, was it confined to a small group opposed to suspended Sheriff Ross Mirkarimi, or was the survey spread out to include a mixture of San Franciscans? No one is perfect, and that includes Mayor Lee. How many of you have as much as used a curse word to someone you are involved with, and the pain of the heart was so hurtful because the curse word used came from someone you love? In other words, the heart was more affected than the curse word. No physical pain was inflicted, just a curse word. You should interview either in person or by satellite the wife of suspended Sheriff Mirkarimi, who was voted by San Franciscans at a higher percentage than Mayor Lee. I presume you view the tape recording of the wife who was inflicted more with the pain of the heart, not the small bruise she sustained that disappeared before he was inaugurated. I urge you to interview the loving wife, Ileana Lopez Mirkarimi, before deciding on recommendation to the Board of Supervisors on suspended Sheriff Rick Mirkarimi.
Good evening, Commissioner. Good evening, Commissioners and ladies and gentlemen in the audience. I'm submitting this CD as public for my public comments here. My name is Pastor Gavin, and it is my case 11048 that I believe that has been long overdue, and I have been denied justice. A delay and denial and justice here by the political family of San Francisco in the memory of Edgar Mevers, Shirley Chisholm, Dr. Martin Luther King, President Lyndon Baines Johnson, former attorney, U.S. Attorney Robert Fitzgerald Kennedy, and on behalf of my mother and father, may they rest in peace, Mr. and Mrs. Gavin, the City of San Francisco, the Ethics Office, Mr. St. Croix, City Attorney Dennis Herrera, 5 Aces, also District Attorney George Gascon, and Mayor Ed Lee have done me a grave injustice. They have violated my rights under the Americans with Disabilities Act. They have violated my federal rights under being a woman and being a black woman here in the United States. I am appalled at this misjustice. My case is much older than the case of Ross Mirkarimi. I should be here in the chambers with you against the 4 supervisors, Supervisors Marr, Cohen, Scott, and Weiner. If this case is recommended to go before the board, and if the 4 supervisors who have a sunshine violation, 11048, I myself will file a complaint with the California State Bar because it is a conflict of interest for them to pass judgment on Ross Mirkarimi when they have committed a misdemeanor, they have broken a state law, they are in violation, and I am appalled and outraged that they are not in here tonight.
Good evening, Commissioners. My name is Tracy Griffin, and I feel that the sheriff is being singled out. And I also feel that it's a double standing, including bias. They have been, it has, in the past, it's been 25 previous official misconduct cases referred to the Sunshine Task Force, which was discussed by the Ethics Committee, which is yourself. However, it had not included a public hearing. So I just feel that the rules should not apply to one person, but the rules should be across the board. And if you want to reprimand one person, then it should apply to all. And thanks for listening. And please make an honest, fair decision as you see fit. Thank you.
Good evening. My name is Vivian Imperiali. I'm a city employee speaking as a private citizen on my own time. Your focus is on ethics, so it should concern you that something unethical is in process, the disparate treatment of two city employees. Ross inadvertently bruised his wife's arm and immediately apologized. On the other hand, our fire chief acted with malice aforethought twice, both when she assaulted her husband and later when she defied a court order to pay spousal support. Her behavior was morally reprehensible, yet there have been no repercussions from City Hall. It is unethical for Ross to be treated so differently. You are in the position to introduce fairness, to put things back in perspective when they have been blown way out of proportion. To punish this man beyond redemption is unbefitting of a civilized society. It is a fundamentally flawed system when a man of this caliber is condemned. Take a moment to look at this man sitting before you. Look at him not as a case number, not as an assignment, but as a man, a brilliant, worthy man with a demonstrated dedication to serving our city. Take another look at Ross. He is a good man.
Thank you. I'm Bernie Shoden. I raised the point that the agreement that Ross signed was probably under duress with the stipulation that all parties would abide by it. Given the absence of Mayor Agnos to affirm my supposition, it is likely that Mayor Lee and the city attorney have broken that agreement. Therefore, the agreement is impugned. Given that, you have a different case. Second, on the question of priorities by the district attorney, the Sunshine Ordinance Task Force unanimously agreed that 4 Board of Supervisors acted egregiously in violation of due process continuously and asked that the district attorney take a case against them. But that was held to be a secondary priority to pursuing Ross Mirkarimi. There is something very wrong with that. I served with Ross as a friend and colleague on San Francisco Tomorrow's board, while he served honorably as an officer of the court in Terrence Halliman's district attorney's office. If that doesn't prove integrity, I don't know what does. Thank you.
Hi, my name is Atusa, and I know Ross for 7 years because I have done some reports and interviewed him for my TV. And during all these years, I saw him working really hard when he was a supervisor in City Hall. I saw him that he was there until 10, 11 o'clock taking care of people's problems, him and volunteers. And then also I saw him how hard he was working where he wants to get as a sheriff of San Francisco. He always helped everybody who needed help. He helped us to stand for freedom and women's rights in Iran. He was a gentleman, he's a great man, and I don't think that if somebody has a problem that we don't even know the nature of the problem with his wife and in a marriage quarrel, they get, angry and somebody grabs somebody's hand, that categorizes him as an abuser, a danger to society, a person that doesn't deserve his job. And you know, I'm married for 20 years. A lot of times I have said things to my husband in the heat of the moment that I don't believe, and I'm angry. I tell him. It doesn't mean that somebody would take that against me for the rest of my life and ruin my career. And some people do get bruised easier than the others. If I hit my hand right here, I get bruised. And my friends too. Just because somebody grabs, it doesn't mean that he beat the person. It doesn't mean that he abuses the person. And as she says, he stopped immediately after she asked him to stop. And that was just a fight to me. A family fight, had nothing to do with his capacity, to his hard work to be a sheriff. And I came to this country because I believe in justice. My children are American Persian because they believe in justice in this country. And I do not think that somebody that has a problem with his wife grabbing needs to be losing his job.
Thank you, ma'am.
Honorable Commissioners, I'm Roland Gordon, pastor now for some 34 years of the Ingleside Presbyterian Church. And I'm here as an American citizen speaking up for justice where I perceive a gross injustice occurring against an honorable, rational, proven, sincere, and committed servant of the people of San Francisco, former Supervisor Ross Mirkarimi, who was duly democratically elected Sheriff of San Francisco with more than 70,000 first-place ranked choice votes, yet summarily removed by our Honorable Mayor Ed Lee for allegations of official misconduct before even taking office. Sheriff Mirkarimi has taken responsibility for his actions in what should have been a private disagreement between a husband and his wife, which occurs in most marriages. He undoubtedly will be a better husband and person as a result of his experience, and with so many eyes now watching his every action. It would have been somewhat of a challenge for me to be here if Mrs. Mirkarimi had received a black eye or a broken nose or ribs or busted up lip or a tooth knocked out and had not forgiven her husband or not spoken out in support of him, but for a bruise on her arm and words said in anger to be classified as official misconduct and hundreds of thousands of taxpayers' dollars wasted and the larger threat of our democracy's majority vote rule potentially undermined, I strongly urge this injustice be stopped. I humbly appeal to this commission, our Honorable Board of Supervisors, and even our Honorable Mayor Ed Lee, who I grew to respect, and in fact wrote and encouraged him to change his position and run for mayor. I appeal to you all now for the good of and unity and harmony and future of our great city, that you exercise mercy, forgiveness, healing, and support for our duly democratically elected brother and servant of the people, Sheriff Ross Mirkarimi, and let him be allowed to take his rightful office so he can get busy doing the outstanding work he was elected to perform, and we know he will do.
I just want to thank you for allowing me to come and say something. I always, in my lifetime, I tried to stay out of politics and religion, but unfortunately I couldn't keep quiet. Last 3-4 months, I'm looking on TV what's going on with the Mr. Mirkarimi. I never even met the gentleman. This is the first time I even met him. The problem comes here is that something happened in the house between the wife and the husband. I want to know which one of you guys didn't have the same problems in your life. Everybody had argument with their wife, their kids. I done it too. So we do get angry once in a while. We always hurt the most closest person to us. So I don't think the specialist could come and say here, because he grabbed something that means this and that. That doesn't mean anything because the expert wasn't there. There was 2 people in that room there. It was Mr. Mirkarimi and his wife. Nobody knows what happened. So even DA's office, the city attorneys saying Mrs. Lopez, they want to know what the Mrs. Lopez said. Maybe they should read this. Mrs. Lopez wasn't the case. This case is politics. And my point to this here is got to be the district attorney and the judge who created that. I personally been dragged in the court for 25 years. I lost 600 acres in Clayton, and I've been sleeping in the garage with 2 kids. Enough with the injustice, and I appreciate it. I don't think you guys or even the mayor has anything to do with these things. There's more power above telling what the mayors and you guys do. Thank you very much.
Commissioners, good evening. Thank you for letting me speak this evening after all the other speakers. For the record, my name is Emil Lawrence. I've spoken before this commission several times in the past. I've been a citizen and resident of the county for 44 years, a citizen of this country all my life. What I see right now taking place is one of the biggest wastes of times I've ever seen. We live in a city with over 1,000 unsolved murders, yet the district attorney has time to prosecute a man that bruised his wife's arm in an argument. You tell me which one of you have the perfect marriage out there. Throw the first stone. You don't have a case here. I don't even know what you're voting on, to tell you the truth. You don't have any suspects because they won't come forward and admit it. It's over. Yet, you didn't prosecute a previous mayor. We used to have a mayor that came into San Francisco picking up hookers in his limousine, bringing them to City Hall at his board meetings. I didn't see any ethics commission involved in that one. We had a gigolo mayor, adultery on campaign night. No investigation there. He came forward and said it was drug abuse, and then he handed $10,000 to $18,000 to her. No investigation there. Now we have Ross. He's being investigated for arguing with his wife. It's the biggest joke you can imagine. If you look back at the history in this city, you look at all the cases here that you haven't looked at, and now you're exploding and expanding on this one. In the biggest deficit in San Francisco's history, you have prosecutors wasting hours and hours looking for depositions on so-called expert witnesses they're going to find in a phone book. Who's an expert witness on San Francisco? You tell me. I thank you for your time.
Hello. What I want to say is that I was here last time, and I'm going to, reiterate the same message I gave last time, that, this is unnecessary. It is a waste of taxpayers' money. Ross should be in the jails, working with the people in the jails, making their lives better. And from what I know from people that are working the jails right now, it's a damn mess. And it needs to be fixed, and it's a mess because the right person's not running it. The people said who they wanted. You guys need to let him go back to work and do his job. They say they're doing this to help Ileana and his son. All they're doing is hurting them. Nothing I've seen has helped her or him. So you need to reverse this, make the right decision, let the man go back to work and do his job. Mayor Lee's guy lost. And I'll say that again, Mayor Lee's guy lost. He's a sore loser, but he needs to let it go so that the people in the jails get what they need and Ross can take care of his family.
Good evening, Commissioners. My name is Erica McDonald, and I am here to urge you to drop these charges, dismiss these charges, and reinstate Sheriff Ross Mirkarimi immediately. This case is not about a bruised arm, and I can prove it to you. I myself had 2 badly bruised arms when a violent felony was committed against me when I was attacked on the streets of this city, only to be denied justice by the very same people. Let me put that there. Only to be denied justice by the very same government agencies who are now claiming the moral high ground in the name of public safety. We need Sheriff Ross Mirkarimi's leadership, and we need it yesterday. I am very upset with Mayor Edwin Lee for bringing these ridiculous charges. Edwin Lee is a longtime City Hall insider who was initially appointed to his position as mayor without anything remotely resembling a public process. Ross Mirkarimi received more than 2,000 plus more votes than Mayor Ed Lee last November, and Mayor Ed Lee is now trying to shamelessly overturn that election. I urge you to not let him do that. And if Mayor Ed Lee has 1 ounce of integrity left, he will end this charade and give this city our sheriff back. I thank you for your time.
Good evening, Commissioners, and thank you so much for allowing us to have this public speaking at such a late hour. Thank all of you for your hard work. My name is Maddie Scott. I'm the co-founder of the Healing Circle for the Soul Support Group, and I am here to support Sheriff Mirkarimi because I lost a son to senseless gun violence in 1996, and his case remains unsolved. This is him here with his son. The last time he was with his son, who died, my son was killed the day before his 6th birthday. So he doesn't have his father. Little Theo has his father, but he doesn't have his father. And in the Healing Circle, we're about keeping families together, not tearing them apart. There's enough families being torn apart here in San Francisco, and I must say thank you to Sheriff Mirkarimi because he has been on the scene. You failed to look at his record. When homicides happen in our neighborhood at 2 o'clock in the morning, you know who meets us there? Sheriff Mirkarimi. When homicides happen anywhere in the Western Addition, he's always there. When there's a funeral, he's there. When there's a community meeting, he's there. He's there walking the neighborhoods at the farmers market talking to us. He's a public servant. He's bigger than a public servant. And I'm here to say that we spend too much money and tax dollars on unnecessary things like this when we can be spending it on unsolved homicide cases. We have over thousands of unsolved homicide cases, and I'm one of them. So I'm asking the mayor and the city and you and all to let's do the right thing. Hurt people, and heal people. Let's get in the healing business and start healing this city. Thank you.
Good evening, Commissioners. My name is Joe Elias Jackson. I'm a native San Franciscan. I'm an elected delegate to the Democratic National Convention and a candidate to the Democratic County Central Committee. My support for Sheriff Mirkarimi is very selfish. I want the people of San Francisco who can't speak for themselves to get the attention Sheriff Mirkarimi was elected for. I am beseeching you to get back to the basics and use your God-given common sense, fairness, objectivity, and ethics. I ask that you not be swayed or biased by predatory acts and the power of the position of mayor, but upon the preponderance of the evidence. Please recommend the sheriff to be unsuspended without pay and returned to sheriff as elected by the majority of San Franciscans. Again, thank you for all you do. And I thank you in advance for your ethical analysis and submit you will deliberate with the highest ethical standards. Please do not stack the decks against him. And again, thank you for what you do. God bless.
How you doing? My name is Larry Haynes, and I'm 100% supportive of Ross. I'm from District 5, and he was the supervisor there, and he's always been very supportive of our group, especially brown and black people, and Chinese also. I think it's a complete fiasco and a total waste of time doing this, and he needs to be back in the office of sheriff, where he do the most good. Because this is a fiasco, and it's politically motivated. I believe that. Thank you.
Good evening, ladies and gentlemen, board member of the Ethics Committee. My name is Alex Amayo. I have been in San Francisco since 1965. Besides the incredible beauty of this amazing city, the one thing that makes me the most proudest to live here is because it is the most liberal city in the world, where we respect diversity and embrace the amazing rainbow of all the communities that call San Francisco their home. Today, though, is one of the saddest moments in the modern history, compared only to the day when we lost probably one of the best mayors we ever had in George Moscone, a mayor who valiantly defended the will of the people in San Francisco. And today, opposite to his memory, we have a mayor who is selling his heart and soul to the half and powerful of San Francisco. Shame on you, Mayor Lee. It could not be any more obvious that your intentions are pure political. You are spending the city's money and resources to try to get rid of one elected sheriff, Ross Mirkarimi. Shame on you, Mayor Lee, for having a double face when it comes to giving it to the influence of Rosa Parks, Tricky Willie, and their circus of followers, who are always trying to run San Francisco. After this is all settled, it will surprise me if in this same room we will have a hearing to penalize you, Mayor Lee, for the injustice and criminal act you're trying to commit. That is why I'm appealing to you, members of the Ethics Committee, not to, under pressure that the so-called powerful influence are putting on you. Remember that the decision you make in this hearing will follow you all your career life. Do not become a Pontius Pilate to Lee, Pack, or Tricky Willie and to others and give in to their distorted campaign. Let's not turn this hearing into another shame event in America's democratic history like when they lost our President Al Gore. Thank you very much.
Hi, I'm Hushain Pakpur, and just wanted to mention a couple little notes that nobody mentioned that. Number one, Ross Mirkarimi was, Sheriff Ross Mirkarimi was suspended on Iranian New Year's Eve, which is March 20th, 21st. Number two, if Sheriff Ross Mirkarimi loses his job, that means that liberal people cannot act in political circle in San Francisco, which is really, really bad thing to happen. And last, and most important of all, you are using all this money, electricity and everything, and manpower for something that is not really important, and I don't know why politically they're attacking Ross Mirkarimi. Thank you.
I'll be trying to be as quick as possible. I've been knowing Ed Lee for over 20 years, and I've been knowing Ross Mirkarimi for about almost the same amount of time. But my question is to all of y'all, his answer, who's in control? Right here in San Francisco. Then the other thing is, my name is Ace, and I've been on this case. And some of those people out there don't want me in your face, but it's no mystery. All you gotta do is check your history. I'm working on a case that's involved with a lot of this conspiracy. Now, the thing about it is, here at City Hall, ooh, it gets silly, y'all. What you say here in City Hall, it gets so damn silly, y'all. Right here at City Hall, it gets so silly, y'all. You know what? Because I'm telling y'all, because I done seen it all. And what I saw might be against the law, like what you're doing right here. Now, and what I heard, ooh, it sounds so absurd. But the thing I want to tell y'all, that one thing's for sure, Ed Lee, he knows me. We worked together when he was with the HRC. And it's no mystery if you ask Ed Lee. He'll say Ace is just working on a conspiracy. But ladies and gentlemen, on a real tip, Ross has so much integrity and so much respect, not only in the Western District, but all over the city. And if you would take the polls of the community and the voters, you would see there's something that's going on here in this milk. It's nasty. Here at City Hall, the whole world is looking at us here in San Francisco. It's a specular right here in City Hall. It gets so silly, y'all. Right here at City Hall, I'm telling y'all. And a big...
Chair Herr and Commissioners, I am glad and very grateful and appreciative to you because you demonstrated to me tonight and at the previous hearing that you do take your oath of office seriously. And as someone who devoted 8 years of their life plus to this commission, and before that 4 years on the Board of Permit Appeals, when that commission had jurisdiction over permits and licenses for people to make a living, I can say from personal experience, it's an understatement to say that it's a thankless task to serve on the Ethics Commission. And it's a thankless task to serve on any commission and be conscientious about following the law rather than what's politically popular. And you've given me faith that you are going to follow the law and the evidence in this case. And the law is very clear, and I quote former City Attorney Louise Rennie, "The Charter does not authorize the Commission to impose any type of public censure upon individuals who have not committed a violation within the jurisdiction of the Commission. The Commission must find probable cause to believe that a provision of the Charter or city ordinances relating to campaign finance, lobbying, conflicts of interest, or governmental ethics has been violated. If the Commission does not find such a violation, no further action shall be taken on the complaint." Thank you. I hope you will continue to serve as admirably as you have tonight.
Good evening. My name is Sylvia Alvarez Lynch. I think I don't need to clarify your jurisdiction more so than a past commissioner on the Ethics Commission. Those parameters were quite clear. Obviously, this is out of that parameter range. And if that isn't clear, maybe we can reference him again if you need to call him. I am here not only because I feel that you should give Mayor Edley and the rest of the people that are trying to perpetrate a political coup an opportunity to save face and throw this case out now. Not only that, I think we need to honor the men and women who died to preserve our right to vote. And clearly, our votes mean nothing to the mayor and those in power, which are greed, corporations who have an interest in getting out Ross Mirkarimi from the political scene. It has long been said that politics in San Francisco is a blood sport. That we know going in, but never has anyone lowered their standard to such a point to sacrifice a family. That is intolerable, and you as a commission should have the integrity and respect for a man who has had a long history in San Francisco to defend its impoverished and neglected. And therefore, I'm asking you, do the mayor a favor. Give him the opportunity to save face and throw it out now.
Hi, how you guys doing this evening? Outstanding job, by the way. My name is Pierre Lamont Pegaron. I live in the Western Addition, District 5, where Ross has ruled for years. Just like to say a quick few things. You know, we all have our little problems and our issues and things of that nature. But one thing about this guy back here, he got your back. Whenever I come to City Hall, he never had a closed door policy. You come see me, what you need? We'll have to take care of you. We'll look out for you. He's always been there for his constituents. It's unfortunate we got to judge this man on some personal issues, you know, because my girl tried to jump out the car the other day, and I snatched her back in it. I didn't want her falling out and getting hit by another car or something like that happening. But we got to look at his record, man. He fought hard to make District 5, you know, a safe place. You know, and another thing I really don't understand is you got police officers out there They're not elected. You got bus drivers out there. They're not elected. It's an elected official, and it gets suspended without pay when you give cops and bus drivers suspended with pay? I don't understand that. I really don't understand that. How could you try to just kill this man? I don't understand it, but he's strong. He's going to make it. He's going to be okay. I promise you that. He's going to be okay because he got our back. We got his back, and I'm going to tell you that. And he was sworn in, and he did his job. He did his job in District 5 for the African Americans. In that community, there was a lot of murders, and I'm sure you all know that. He stopped that by just being out there talking to them, by just implementing programs that would get these African American youth something to do once they got out of jail. Instead of being out there on the corner, I give you a job working in the city. You pay your restitution and you pay your child support, but you got a damn job. You're doing good. And they took off on that. That's why we need him down there in the sheriff's department. That's why we need him.
Good evening. My name is Valerie Tully, and I'm here representing the Latino Democratic Club. Ross Mirkarimi won the election for sheriff with 53% of the vote. Our entire system of government proceeds from the will of the people as expressed through orderly, monitored, and validated elections. When one elected official's action has the result of voiding an election of another, that elected official's action must be addressed a wrong that is equally fundamental to our democracy. To do otherwise sacrifices our democracy too cheaply. Many members of the Latino community in San Francisco are within a generation of mass disenfranchisement. These memories of disenfranchisement arise from experiences abroad in undemocratic regimes or from experiences in the United States where Latinos were and are systematically denied democracy. The suspension of Sheriff Mirkarimi stirred those painful memories, and this process to suspend him began with disenfranchising a Latina and tearing her family apart. We, the San Francisco Latino Democratic Club, ask you reinstate Sheriff Mirkarimi, and further, we urge you to create a diversion in lieu of conviction program that is consistent with San Francisco's values of alternatives to incarceration and of respecting the dignity of every person who enters the criminal justice system. This is excerpts of a 4-page letter written and has been submitted to you by the Latino Democratic Club. And I want to thank you, commissioners, tonight. You have been very fair and very just, and we appreciate that in the public's eyes. And I also want to let you know that I, too, am a former commissioner on the Commission on the Status of Women, and I understand what is DV and what is not DV. And guess what? This is not DV. Thank you very much.
Hello, my name is Alicia Maria Gomez. I'm here today to ask that you immediately reinstate Ross Mirkarimi. I hope that we all take a moment to observe that the fact that this hearing today follows the Memorial Day weekend. Democracy, the power of the vote, is fundamental to this country, and that is what wars have been fought over. Another thing that's fundamental to this country is the freedom from invasion in our everyday lives by government, freedom from government. I struggle to understand how an ethics commission, or how to put it, what price, what crime justifies invalidating the votes of 53% of San Franciscans. This is a commission that typically looks at election law, and that is, from my perspective, what happens here. We have a basic issue of democracy at stake. If we are going to be here litigating a plea bargained, admitted conduct and unconvicted conduct, where is our standard going to be for anything that comes forward in the future? What precedent are we setting? What conduct in our everyday lives will you be referencing in the future? If we're going to lower the standard as to what will be the basis for invalidating an election, it must be a strong case, something that where we're going to be litigating everyday activities as the basis for invalidating an election of a sheriff simply cannot be a precedent worth setting. Thank you, and I, again, am also a member of the San Francisco Latino Democratic Club, and I hope that you will take our public comment very seriously and the public comment of every...
Hi, good evening. My name is Richard Stone. I'm a member, I'm a proud member of the San Francisco Green Party, and also have served for Ross before in the past when he was elected in his first term as supervisor. And I must say that with all the principal endeavors that I've seen him, that even dating back before he was elected, such as being able to get the environmental impact report that actually stopped the building of a nuclear power plant, all the way up to the time that I worked with him with the formation of really sane laws for medical marijuana, and most importantly, I think in terms of the community policing and all of the great accomplishments that he has brought to the criminal justice community, I think it's a real crime that for something that I think that is not so serious in nature that it would be stretched to the limits of that it has been brought to this point. I really think that he should be reinstated, with back pay, and I just, even though it's really sad to have to actually go through this process, I'm really glad that the journey towards having actual due process is actually come a little bit farther than I thought it would, and I really commend you guys on your efforts, and I really hope that in the ensuing sessions that not only will due process take hold, but justice will also be served, and Ross will be exonerated. Thank you.
Commissioners, thank you for hearing my remarks. I'm here today because I'm upset that you didn't do your duty last month and stop this debacle. The sheriff is being railroaded by an unscrupulous mayor, squandering public funds for his own aggrandizement. The mayor is claiming official misconduct, but hasn't cited a single specific conflict of interest or governmental ethics law that has been violated. That should be enough for you to vote immediately to recommend the reinstatement of the sheriff. The law is quite clear on this point. To claim official misconduct, the mayor must show either the sheriff did something a sheriff shouldn't do, or didn't do something a sheriff should do, or did something to violate a specific conflict of interest or government ethics law. None of the above applies. Instead, Mr. Keith is using this proceeding to produce a telenovela at public expense. If he wants to produce a telenovela, he should get private funding and hire an actress with a green card. For the effort the mayor has put into this, you would think the ballots were found floating in the bay instead of going into the hopper of the counting machines. That didn't happen. We didn't hear the sheriff shaking down fast food restaurants for bribes either. Mr. Mirkarimi has suffered big time for arm grabbing. That has nothing to do with official misconduct. Nothing. You have only one ethical choice. Vote immediately to recommend the reinstatement of the sheriff. Don't waste any more time with this chatter about witnesses. Don't indulge Mr. Keith's absurd fantasies. Do your job now, please. Thank you.
Good evening, Commissioners. My name is Laurel Muniz. I want to thank you for giving me the opportunity to speak tonight. I'm here today because I strongly believe that the Ethics Commission has a duty to the voters of this city to uphold the will of the people who democratically elected Ross Mirkarimi to the office of sheriff. The country is watching what you do here. Undoing an election of the people is an extremely serious matter. The suspension of our sheriff didn't happen because he engaged in official misconduct. Our sheriff was suspended without pay due to political pressure, the same political pressure that has victimized his wife, Ileana Lopez, and has had a traumatic impact on his young son, Theo. I ask the Commission to recommend that the charge of official misconduct be dropped and give us back our sheriff. Thank you. I also want to submit to the Commission a resolution that was passed by the Bernal Heights Democratic Club in support of Ross Mirkarimi and opposing his removal from office. The Bernal Heights Democratic Club opposes the removal of Sheriff Ross Mirkarimi from office as proposed by Mayor Ed Lee for the alleged misconduct. Requests the mayor reinstate Sheriff Mirkarimi in the interest of justice and what is best for the city and county of San Francisco. Encourages the members of the Ethics Commission and the Board of Supervisors to oppose the removal of the duly elected sheriff. Thank you.
Thank you, commissioners and deputies, for your service and the opportunity to speak. My name is Brian Webster. I'm a community organizer and marketing professional. I work with business, labor, and community organizations. I've lived and worked in San Francisco for over 25 years. I support the sheriff, I support the mayor, and I support the DA. As to whether the charges should be sustained, this situation is all about politics. It's not about the law. The situation has turned into a political witch hunt, and that is clear and obvious to the people of San Francisco. Common sense says that there was no case against Ross, but politics says there was. Ross got indicted, and San Francisco got a black eye. The mayor suspended Ross, and San Francisco got another black eye. The city and this administration should back off and stop shooting itself in the foot. It said that what's at issue here is wrongful behavior. The witch hunt against Ross is wrongful behavior. It would be unethical to not let our elected sheriff go back to work. Please, please stop wasting our time, money, city resources on this witch hunt. Thank you. Thank you very much.
Good evening, Commissioners. My name is Rosario Cervantes, and I represent myself as a community and neighborhood activist, and I live in Excelsior District 11. We live in a world full of gray area, and people choose to live in the black and white and accuse Ross of domestic violence. The mayor's role appears to be retribution, punishment that is considered to be morally right and fully deserving. I really disagree with how the mayor is handling this whole matter. Restorative justice is a theory of justice that emphasizes repairing of the harm caused or revealed by criminal behavior. It is best accomplished through cooperative processes that include all stakeholders. Three principles forms the foundation for restorative justice. Justice requires that we work to restore those who have been injured. Two, those most directly involved and affected by crime should have the opportunity to participate fully in the response if they wish. And the government's role is to preserve a just public order, and the community is to build and maintain a peace, not to destroy a person, not to destroy his career, or also destroy the remnants of his marriage and separate him from his wife and child. We got to open our minds and be open and live in those gray areas. There are circumstances that sometimes are beyond our control. I voted for a man who has experience to be a sheriff. He's worked on legislation to give reentry to criminals to bring them back into society. He has the commitment and the know-how. If anything, Ross is a workaholic. We need his dedication and commitment. I ask you to stop spending our taxpayers' money with furthering this court. I ask each and every one of you here on the Ethics Commission to do what is right, not what the mayor and DA Gascon wants. Theirs is a power issue, and I believe this is unethical. Stop the attacks on his personal life. Ross is a sheriff. I voted, and I want my vote to count. Thank you.
Good evening, Commissioners. My name is Lori Lederman. For the last 37 years, I've lived in San Francisco. I am proud to support Ross Mirkarimi for his outstanding work as a supervisor in District 5, for his tireless leadership on local law enforcement issues, for his courage, and as the duly elected sheriff of this city who should be returned to duty immediately and made whole for the losses associated with being wrongfully suspended without pay. I am distressed by the miscarriage of justice and the public assault that has been waged on Sheriff Mirkarimi by the district attorney, the mayor, and the mainstream media, all of whom have shown a total disregard for the well-being of Eliana Lopez and their son Theo. In their unprecedented zeal to destroy Sheriff Mirkarimi's ability to survive not only as a public official, but as a human being, they have trampled on his rights, the wishes of his family, and along now with the city attorney's office, they are abusing much-needed tax dollars of San Francisco residents with this manufactured charges before you. I want to speak to you in terms of the substantive issue, which is whether or not Mr. Mirkarimi has engaged in misconduct that would warrant permanently removing him from office. I've spent 27 years as a union representative advocating for working people in a variety of workplaces, and I would say absolutely the issues in this case simply don't come close to warranting termination of employment. This is such an obvious example of the mayor making a political decision and then tasking the city's attorney's office with developing a case after the fact. Nothing that is alleged to have occurred took place in the course of Mr. Mirkarimi's duties as sheriff. All of the allegations deal with matters entirely and exclusively off the job, out of the workplace, with no relationship to his duties as sheriff. He has already been fully punished under the law and treated to a persistent public humiliation of a greater proportion than I can recall in my 37 years in this city. It is your opportunity and your obligation to rise above this circus, to exercise reason, to rescue due process, and to restore Ross Mirkarimi to his rightful position as sheriff of San Francisco.
Long evening, Commissioners. My name is Dennis Moscofian, and I was born and raised in San Francisco. I'm a father of 3 children, and I'm in District 5. Lori is my partner, my wife, and my best friend. I, too, spent decades working as both a union worker in San Francisco, in the newspapers, in the press rooms, and also as their representative. And I have never seen, even in the most egregious management attack on workers, this kind of assault that has gone on from the mayor and this Republican DA that we got from Arizona, and of course the city attorney now, who is a friend of mine, but I'm ashamed of him and I've told him so and I've written, because what this is a public lynching. Now you guys, I'm concerned about, are going to be used to make this somehow something that you then shift to the Board of Supervisors, and then the Board of Supervisors in an election year have to then decide, gee, do I sacrifice my future relationship with the mayor or my future career, or do I do what's right? Nothing in this case, nothing in the New Year's incident rises to the level of a crime. Yes, he pled guilty to false imprisonment in a deal. Yes, he's copped to it, he's explained it. He was guilty of whatever happened, but that kind of incident does not rise to the level of official domestic violence. There's no history, there's no pattern, there was no killing of public officials, there was no burning of buildings, there was no theft, there was no falsifying addresses to get elected. There was a family argument over the custody of Theo, and a real problem. And I don't know about you guys, but I went through something like that. And I felt real pain when I thought I was going to lose the custody of my children. I just want you to recognize that you're going to be used, and I think you're being used by our mayor. And I want you to recognize that and pass on to the Board of Supervisors.
Thank you, sir.
That the Ross be
I'd invite the next speaker to come up. Thank you.
Hello, good evening. Thank you for giving me the opportunity to express my feelings. Sorry if I'm feeling a little nervous. I feel sad today because I see good people right in front of my eyes. And what's this happening right now? This is turning into a circle, and what I'm asking you is, please do not be part of this circle. I think there's better things to do in San Francisco and all over the United States. What you're doing right now, you're destroying this good man's life. You're tearing his family apart. You say, I've been hearing about criminal violence, but what we're doing to him, it's a violent crime, destroying a family, destroying this good man career. Please, I'm asking you, do not be part of the circle, and I'm sorry, I feel nervous. God bless you. Thank you.
Good evening, Commissioners. My name is Eric Brooks. I've been a grassroots organizer for environmental and social justice in San Francisco for 18 years, so I know the vagaries of City Hall pretty well. And I'm here to ask you, at the earliest possible opportunity, to send a strong message to the Board of Supervisors that it should, at the earliest possible opportunity, reinstate Ross Mirkarimi as the duly elected Sheriff of San Francisco. I'm happy to report that I'm also a Green, it's a SF Green Party, and even though Ross left the Green Party to become a Democrat, we had the wisdom to realize when a serious breach of democracy was taking place, and we put a statement up on our website in support of returning Sheriff Mirkarimi to office. I would encourage you to look at that statement. It's powerful. It's at sfgreenparty.org. On the case itself, let's just refocus. We're talking about a misdemeanor case in which the court already decided that the remedy to this is family counseling. Okay? This does not by any stretch of the imagination rise to the level of removing someone from office. That's just absurd. And I watched this hearing today, and what I saw from the mayor's attorneys was an attempt to take a very large industrial-sized pot of messy spaghetti and throw it at the wall to see what would stick. In my 18 years in San Francisco, I have never been so appalled by the behavior of public officials as I have with that display. And please, your job as ethics commissioners is to consider the politics here. That's what you do when you address campaigns, is look at politics. If you go with this nonsense, who's going to be next? When the progressives get a mayor in, what's that mayor going to do to the moderates? This could really open up a ridiculous can of worms, and you need to turn it back.
Hi, my name is Tracy Brown, and I just wanted to thank you guys for giving me the opportunity to speak, although I had to leave and come back. It's hard for someone like me with 4 kids to come out this late at night and actually speak at 11 o'clock at night. And there's a lot of other people who would love to be here and voice what they think. I actually worked on Sheriff Mirkarimi's campaign, and it was a great campaign, and we were successful at getting him elected. And so when he did win, all of the kids that I worked with, my own 3 kids who are eligible voters, they said, "Finally, Mom, you won an election." Because I've worked on progressive campaigns all of my adult life. Because it's my value, and it's also a San Francisco value. Restorative justice is a San Francisco value. Harm reduction, the way we deal with homeless, those are San Francisco values. And so the way we deal with this is also a San Francisco value. And so I'm glad it's coming before you. I'm very pleased with how the discussion went today. I have faith in our system. I do have to say that. Ross has been there for the people. He has heard our voices. I don't have to explain all of that. But what I do want to say is that there was some voice that was not heard in all of this, and that's Ileana's voice. And as a woman, I have to say that if this was my family put, on trial, I would be devastated. And I hope that you, as people who support women, as people whose agencies support women, that you will look at what she is going through and hear her voice and allow her voice to emerge in all of this. You've heard a lot about Ross, and I love Ross. But you haven't heard about Ileana, and you haven't heard about how she feels, and you haven't heard from her, and a lot of people haven't heard from her. And also, Lynette Peralta Haynes, who's being on the witness list, she's pregnant. She just delivered a baby. I doubt that she'll be able to come in. So please remove her from the list. But you should listen to the voice of women. I feel our voice is being lost here.
Good evening, Commissioners. My name is Maria Guillen, and as they say, it's about who you know in City Hall. And this evening, that important person that I know in City Hall happened to be my union member, who is the custodian here, who happened to have some extra fried chicken because we didn't have dinner tonight. And bless his heart. I'm actually, more seriously, I want to say that for me, being here, standing with Ross, it's as simple as the 3 R's. And in this case, those 3 R's are redemption, restorative justice, and reunification of family. Redemption is much more positive and proactive quality. And I think it's something that I used to think San Francisco was all about, right? Since we all are human, we all have our flaws. I always have thought that it's those that a person's worth actually is doubled when you know that there's been a challenge, a moment of shame that they've had to face, and then make amends. I think that makes for a much wiser and stronger individual, and also much more compassionate. That's something that we will all need at some point. And then in terms of restorative justice, it's been explained a little earlier tonight, but let's restore peace with our justice, not just punishment. Punishment will, in itself, will only will continue the cycle of violence. I also want to speak on the importance of family, and that's without question. I personally do not know of one family that it was without some form of dysfunction. You may be different, but I know that families must work hard and sacrifice to maintain family unity just amongst themselves. But consider when an obtrusive, overbearing, outside entity plays havoc on the family.
Thank you. Thank you, ma'am.
Good evening. Edward Dazowski. Just to speak briefly about the politics of political assassination. I believe Ileana was a victim of a scam and a sting operation. She was lured into making this video, which hasn't been mentioned. And when that video was obtained by Madison, the call went to Philip Bronstein. And Philip Bronstein, that was day 1. On day 2, Philip Bronstein had lunch with Willie Brown. So Willie Brown, and they talked about the Annenberg position. On day 3, Madison talked with Bronstein again. I believe at this point the decision was made that they should call the police, that she should call the police. And that is where it went from there. Then you get our district attorney ends up with tainted evidence, and he has to strike a deal to get it out, which was done properly. Then it passes on to the mayor, and here again I believe we have the influence of Willie Brown, where they were at supper with their wives, and if they went into the men's room and Willie said, you have to you have to dismiss the mayor. And all of this is to deprive the people of a decent sheriff who is a champion of the people. Thank you.
Good evening. I just want to tell you all that I respect how difficult this decision is going to be for all of you to make. But it's clear that there's only one thing on the table here. Was there official misconduct? I hear a lot of people making accusations, that have not been founded. I want to say one thing. If a man loses his job because he makes a mistake, it's a poor, poor day in America when the cycle of abuse is continued by depriving a man his ability to provide for his family.
Hi, good evening. My name is Sherry Zinn. I work at San Francisco General, and I've been a proud civil servant for 18 years. My first meeting with Ross was when I hear, "Hey, wait for me, you guys." We were marching down the road. I don't even remember what we were marching for. But I turn around, there's Ross. "Wait for me, I want in on this action." That was the first time I ever met him, and I thought, wow, what a great guy. For the past 18 years, he's really showed me what an ethical, humane person is. And he's really taught me that lesson. Just last week, when I was talking to him, and I said, "Wow, Ross, if that's what you did, then I am so guilty of false imprisoning somebody. My son, we had many, many fights on the way to the mall over tennis shoes, and I turned that car around and went home. I'd like to call myself a good parent for that." But when I told that story, what did Ross do? He said, "No, Sherry, this isn't a laughing matter. What I did was wrong. I'm never going to forgive myself for that. I owe it to my wife and to my child and to San Francisco to set it straight, not to treat this like it's a laughing matter, to take this as serious as I can." Now that is a true ethical person. That's true humility right here. How do we not let somebody like that be our sheriff? I'm also a bargaining team member. From the city side, we heard over and over and over, "It's the city's will for you guys to have to pay for Prop C." Well, again, it's the city's will to have Ross Mirkarimi be our sheriff. And please, let it be the city's will. Give us our sheriff back. And most of all, give Theo his daddy back.
Hello, Commissioners. My name is Rick Hauptman. I served for 10 years on the San Francisco Relocation Appeals Board under 3 different mayors, 4 years as its president. I realize what a lofty decision you have in front of you. I worked on these similar matters of displacement for 10 years, as I mentioned. I am the past president for political of the Harvey Milk LGBT Democratic Club. I have been a member and an officer of the local chapter of the Nationalization for Women for the past 39 years. I'm currently on the Equity Advisory Committee of the Human Rights Commission. I've known Ross Mirkarimi for more than 30 years, and I've known Eliana Lopez since she moved here, and I was there for the baby shower and the birth of Theo. Your position right now, it's such overreach. It's so beyond the pale of what a commission or a board should be doing. It's political payback. And one thing I'm taken by tonight is, since I've been involved in San Francisco politics for 39 years, but I still apologize for my Brooklyn, New York accent, the folks in this room, gay, Latino, the Labor Council, SEIU 1021, seniors and disabled people like me, they're all here tonight. They've been here for 5 hours like you have. And they're pretty much unified in saying this is overreach beyond anything one could imagine. And I hope that you take that into account when you look in your heart and your souls. And please turn it down. Thank you.
Hello, Commissioners.
I'll be very brief. It's been a long afternoon, a long night. My name is Joseph Lambert. My wife and I are longtime citizens of San Francisco. We've been small business owners for 27 plus years. I consider ourselves very civic-minded. I even at one time had aspirations for politics. I got an undergraduate degree from San Francisco State. But seeing what's going on in this city with this particular case really is nauseating. It's the same as going on through the country right now with the right wing trying to steal the next election that's coming up. I would ask you and plead with you to do what is right, to reinstate this man to his job. I am very upset by the fact that when I vote, and I don't want someone to disenfranchise my vote as has been done in the last case, with the second term with George Bush, when the U.S. Supreme Court, was that the people's vote was set aside and was appointed by the U.S. Supreme Court. And I know in San Francisco, they have the saying about this is a city that knows how. I know on a social level, I mean, it's very liberal. But politically speaking, what has happened in this particular situation with the hijacking of Sheriff Ross Mirkarimi's career is akin to what the same old backroom politics has happened before. So politically speaking, San Francisco is not progressive. And you have the illusion of being a progressive-minded city. So I'm just urging you to do what is right, to recommend that this man be reinstated to the job of sheriff, and let the people decide. We're the ones who voted for him to be sheriff. Let him run his term, and if we're not satisfied, then we'll know what to do. Thank you for listening to me.
Good evening. My name is Rebecca Zabaleta, and I'm here to support this gentleman right here. And you guys have family, right? Like everybody have family. Hope they touch your heart and work, because what we do in this country is horrible. We see a lot of police kill like people, and we don't do nothing. And because this man, he just holding his arm for his wife, you guys judging him like nothing, like he doesn't have like values. He has a lot of values, and he's sitting here, and he put his youth face, and you guys look at him like how sad is because his family is not here, right? We had to touch our heart, and we see what's going on in this country, and touch like everybody else's heart, and TV right now, and looking at us like spending 5 hours, spending our taxes here, and we don't do nothing, just like judging him like he's doing the big deal in this little thing. Like it's just fighting wife and husband. I don't think it's right to be here like spending time and do like nothing important. We have more important things to do. Like, for example, our economy is horrible, and we don't focus on that. And those two people say like, we do a crime, and they're trying to looking on his records on that phone. Come on, let's do something else better, and don't wasting time, because time is precious.
Good evening. My name is Tammy Bryant, and I want to thank you all for being here. I'm a constituent in District 5 and worked with Ross Mirkarimi for 7 years as supervisor. And I just want to make a note that it's been unanimous, the support for him. You had people in the overflow. I don't know if you're aware, and I just want you to know that this room was filled up, and the room was filled up in overflow, if not 2 rooms. There's a lot of people. We are speaking for people who can't be here, and I'm going to speak for one of them. I'm going to read his statement. He's Professor Mike Whitty. He's an adjunct professor at USF, and he's a professor of ethics. Dear Commissioners, as a professor of ethics, sound judgment must include the basic principle of law, making the punishment fit the crime. Taking job and career for a misdemeanor unrelated to job performance is disproportionate. Having taught ethics and labor relations, I believe this obvious fact in this case should result in the Ethics Commission declaring there are no grounds for dismissal from public office. In addition, the lack of balance and journalistic integrity in the media has poisoned the well of community understanding and judgment, making any truly fair hearings doubtful by taking the job and career of a public servant and setting a bad labor precedent. Again, that's Professor Mike Whitty from USF. Thank you.
Hi, my name is
Larry Edmond. I'm probably the first out black person who ran for mayor, gay mayor. Black gay ran for mayor in 1989. Although I know Mayor Brown is going to get an award for doing great achievement for LGBT. But as the president said, we can get married today. If you're not a good ethic committee, I never wanted children. And it scares me that what you would do to a great man like this in a city like San Francisco. The world is looking. You're going to make everything that we've ever stood for look terrible. By one little incident on a New Year's, that's like Thanksgiving, and I mean like a Halloween and Thanksgiving. What do? You get drunk and you do something on New Year's Eve. And I'm going to Co-op, Community United Against Violence. I would graduate this month in June. Violence is a cycle. This is not a cycle. It's repetitive and over. So this is not a recycle. And if you're going to make this world a better place, world peace for everyone, we need to do the right thing here in San Francisco. I represent the medical marijuana community, people on SSI. We have 108 people on Medicare in this city and 112 on our SSI. We have 800,000 people in this city. 230 people are on SSI. You are really harming elders, seniors, LGBTs. Our future depends on here. And if you don't do the ethical and the right thing, we have no justice. It's time to move forward like our president say, not backwards. All the bad things, women couldn't vote 270 years ago. You have been burned as witches. We don't want you all to scare us. We don't want our people to think that we didn't know who you are behind your heads. Thank you. Move this ahead.
Hi, my name is Terry Lukowitz, and I'm a member of SEIU. I'm here to let you know that 4 years ago I was laid off my job. I haven't been able to work anyplace. The union did actually hire me temporary right now. But I'm listening to these lawyers. I'm seeing what she's doing up there. I know what it costs to keep all this going. And we had a contract that we were trying to get more money or keep our insurance and everything not too long ago. And I'm seeing all this money for something that I don't understand. It's like a circus, and it's just like it's going and going. And this should be done. And you're going to go through another month, 2 months. It's going to be the money. They're saying we don't have no money for the people that's working for us. A lot of people are not working. Some people have been laid off. Some people have been cut down on their pay. Luckily, we were able to keep our insurance that we didn't have to pay this year. And then maybe in 1914, is it? We get a raise. And then we have to pay into our retirement. And we're not barely making it, but all this going on here, paying them a lot of money. I mean, I just don't understand it all. I know you have a hard job, and I understand that it's very difficult. But seeing all this going on, it's like a circus. And it's just wasting money that we fought to get for everybody that's working in the city. And we're not getting it, and it's going here. For what? So I thank you very much, and I hope you do the right.
Thank you all very much. It has obviously been a long night, but I thank all of you who have been here, and the lawyers for their advocacy, and the court reporter who has worked very long with very little break. Before we adjourn, we need to do two things, and first I want to give Commissioner Studley a chance to speak.
I want to thank everyone as well, and thank you for your respectful comments. Because it's so confusing, I just wanted to explain that we are here, we have this job, because the voters passed an initiative that created this process that says when a certain thing happens that the mayor is entitled to do, that it created the checks and balances that the Ethics Commission has this responsibility to assemble a record and make a recommendation. We believe we don't have a choice to cut that short. We have to do what the voters at another time by initiative created. So I think the one thing that we would all be unanimous about is that we are all aiming to do the right thing here, but we have to go through the steps to figure out what the right thing is for us to do. But I just want people to know that we can't walk away from this. This, too, just like an election, is a voter-passed initiative by a set of our fellow citizens some years ago who thought that this was the best way to protect the city and county. That's all.
Thank you. We need to make a motion to pass the decisions that we made this evening. I'm not going to recount them all, but what we'll do tomorrow is assuming the motion passes, we will issue a press release that fully explains the decisions that were made. Is there a motion to adopt the decisions that the Ethics Commission made throughout the course of tonight's meeting?
So moved.
Seconded. All in favor?
Aye.
Aye. Opposed? Hearing none, the motion passes. Okay.
Motion to adjourn.
Is there a motion to adjourn?
So moved.
Second.
Second.
All in favor? Aye. Meeting is adjourned.